o'clock, so I will go ahead and call this work session to order. Judging by the number of folks in the room, this is clearly an issue that the community cares about and wants to weigh in on, so I think that's awesome. Thank you guys all for being here. Just to give you guys kind of an overview of what I think we'll do, Kelly has given us some draft reporting for the current grant program that I'd like us to review first so that we can get those finalized and current recipients can start the reporting process. And then we'll start looking into next year's grants. If that works for you guys. Okay, so in your packets, there are, there should be 3 different reports, one for capital investment, one for the operational, and then one for special projects. So why don't we start with capital investment, since you've got that on top, so do I. What are we thinking about, just generally, have we captured everything here that we are interested in knowing? For those at home, I'll just kind of describe. These are for our reporting requirements for those who currently have grants with us. And so we want to do a standardized form so it's easier. You guys know what we're asking for, and hopefully that makes it simpler to get that information to us. So the first page is basically just some just general information on the organization, how much the grant was for, when the project started, when it ended, have the funds been fully expended, those kinds of things. So pretty straightforward. And then we ask for a narrative, which is has 4 questions in it right now, 1 to 2 paragraphs per question. So, I mean, I think the general results of the project, were they achieved as expected? I think that's a good sort of basic question. Talking about how people intend to sustain that project over time. And then describe any significant variances between proposed and actual grant expenditures as outlined in the attached financial reporting spreadsheet. Do we want to, the question in here in red is, how do we want to define significant?
By percentage or dollar amount, is that the question?
I would say probably somewhere around like 10% would be, Nathan and I talked about this yesterday.
Yeah, I think
so
a percentage
this morning.
Yeah, I'm thinking percentage so that it's...
That would be a clearer picture than an actual dollar amount.
And it's 10%,
15, somewhere there.
I mean, particularly for these ones, because they're capital investments.
Would there be restrictions of any kind for a match being from another grant, or does it have to be cash in your program? Because if you're using match this year, we'll say from some other grant stream, so next year we're bumping it to 20%, but that grant is gone. So, you know what I mean? So how are we?
I don't think we're prescriptive on where the match needs to come from, so long as it's not county funds. Right. So like, what would not be allowed is if you came to us and some of your cash on hand were previous Gilliam County grants. So you cannot use Gilliam County money to leverage Gilliam County money. You need to go out and find another funding source, basically. As your, but it can also be in kind. So, you know, if you've got a child care and you've got parents that are coming in and volunteering, or you're doing fundraisers and parents are putting in time to do that, then all of those would go into part of your match, basically. Other questions? All right, let's look at the scoring criteria. Is there anything we want to alter on the criteria that we looked at? We did 60% benefit to the county, 20% matching funds, and 20% necessity of county funding.
How did staff feel that those percentages worked in last year's cycle?
I wasn't involved in the review process, but I didn't hear any complaints. I didn't hear any negative feedback about it.
I mean, I feel pretty comfortable with it. I mean, I think
If
the
it
bulk,
works, then there's no reason to change it.
yeah, I think the bulk should always be what's the bottom line for the county, what's the benefit that we're talking about here. And we are trying to encourage those matching funds, so I think that's important to leave that in there. And then, of course, the necessity of our funds being there to help is, you know, so I feel comfortable with where we are. Do we want to require the applicants, are we still on the same page about requiring them to develop and submit a sustainability plan
Yes.
to be eligible?
Yes.
Okay.
And that's one thing we have to remember too, as we raise these percentages, is that is our goal, is to continue to help these entities become sustainable on their own and not totally reliant on county funds, because we don't know how long we're going to have those county funds to be able to support. We don't want you to fail because
Of a lack of plan. Yeah. Yeah, go
I
ahead.
have a question on sustainability plan. So, are you gonna have a guideline to write that?
that's a good question.
I mean,
We could.
is it supposed to be a page? I don't understand. Because, we're gonna have to do it ourselves. And we're not taking the funds to hire.
So we need an outline of what we're asking for.
Yes, that would
In
really
your,
help.
what we're asking for you to provide to us for a sustainability plan.
Yeah.
Okay,
Yeah.
sure.
Because in my mind, I'm thinking a paragraph or two.
Right.
And I don't know.
Or even a spreadsheet that says, this is what we use the grant money for, this is the amount of money we used, how do we foresee
Yeah,
making that sustainable in
Yeah.
the future?
yeah,
And what is the long-range plan? Is that going to happen in a year, 2 years, or 3 years?
yeah. The guidance would help me
Yeah.
tremendously.
Me too.
And there are a few programs, for instance, the Arlington Help and the Common Food Pantry, to where like the whole amount of funding came from Gilliam County outside of volunteer match. And it's going to be really hard for us to create sustainability planning when it started that way, it's still that way, and how are we going to get to that sustainability, because, we don't have local resources like places to ask for money, because everybody's already asking Waste Management and wherever for money. So it's going to be really hard for us to get there, and that's where I think, your outline is going to help.
Yeah, and I should say, I think, hopefully I'm not speaking out of turn for the commissioners, but I think we recognize that not everybody that's in that pool is the same.
Right.
So there's some entities that we have, I'll throw out as an example, we funded Summit Springs Village last year. We know that when they're at full capacity, they're sustainable. And so their sustainability plan may look more like a marketing plan.
Right.
Because theirs is just it's a numbers game. If they have enough in there, then they cash flow positive and they're sustainable. Other entities like Help, there isn't a mechanism to generate that. You don't have a customer or a space that you're renting out, for instance, that you're going to be able to generate. So I think we recognize, and so part of our challenge in these sustainability plans is going to be giving enough guidelines so that folks know what to respond to, but also recognizing that each of the individuals that are in that pool have different sets of challenges and different opportunities to be more sustainable. And some folks I think we know probably are never going to get there completely because of the work they do. And
If you're
so,
totally reliant on donations and grants, then that's a totally different animal.
Lori,
Well, I just wanted to say that I'm involved with a couple of organizations that have applied for this money for the operational funds, and when this first came about, it was like, oh my gosh, you know, but I said, what they're trying to do is force you to look, to brainstorm, to say, okay, if it's gone, what are we going to do? And if you approach it like that, say, what could we possibly do? Then that'll get you started thinking. And maybe you won't ever get there, but maybe you'll get closer to there. So it's just kind of brainstorming, like,
Yeah.
so, and if I can help you, I don't know what your project is, Carrie, but is it the same program as hers?
It's basically,
Where
you
is
know, they
it?
do the food pantry and they do the help to the
Okay.
community for energy assistance and things.
But they were surprised at what they could think about. So, I mean, I'm not an expert or anything, but I'm willing to sit down and talk to both of you and brainstorm and other things. So,
We can be surprised about what's out there that we didn't realize if we
Yeah.
utilize other
Lots of-
resources.
right.
Yeah.
yeah, I
Go
think
to other
that's,
counties and ask, what are you doing?
I think that's really the essential question for those who are taking operational funds that you need to ask yourself is, what would we do if the county didn't have these funds to provide to us? That's really the crux of what we're getting at, and asking boards to be creative about where those funding sources may be. Because the other thing that, just to keep in mind, is that there is a finite number of resources, and so the leaner that we can all be upfront, the longer we can stretch the support. So the more that we can sort of operate within some boundaries earlier on, for those who can't get there, there's more funds to carry us longer then. So we're trying to avoid people coming in and say doubling their ask from last year. Because what that does basically is shortens by 1 year the amount that we're able to support them. And that's not sustainable for anybody. So I'm glad you brought up that question, because I think that's really the crux that we're getting at, is what would happen if the county funds dried up tomorrow, basically. Go ahead.
And I appreciate your thoughts and your comments, but I just want to say one thing. I have looked for other areas, and sometimes we're promised and they don't carry through. And that's what I've appreciated about the county court. You say what you're going to do, and I appreciate that for the people of Arlington. Because without you, yikes.
Yeah.
So,
Yeah. And our hope, I think, in requiring this is that allows us to be there longer for people. You know, the more that we can be economical up front, the longer we can be a resource, basically.
Well, and this is, it's always a work in progress. So, you know, if some of these things don't pan out in 2021, then we look at it again and make it so that it works for everyone. That's why we're here.
Okay, so wrapping up this one, let's look at the application process. How did we feel about the review process for these? The idea that Kelly does the initial just review to make sure everything's completed, it's on time, it's an eligible entity, it's in the right pool, and those things. And then we do a review team who ranks it, and then these go before the budget committee. So we do that as part of our budget process. How did we feel about that?
I thought it worked well. It does work well. I would like to be sure that the full applications are available for the budget committee and the court, so that, you know, the summary is really good, because the committee delved in and asked questions and, you know, probably answered some questions we would have, but I still asked to see those full applications just to get a bigger picture of what was being asked. So, I agree.
Um,
What did you think of the process? How did you think it worked out?
I thought it went really well. There was a lot of extra help when the applications were brought in this year, but I think that was just getting used to the process, and there was a really short timeline
Right.
to get the applications in the first round this year. So I think after that first year under our belts, I think this next year is going to go a lot smoother with getting the applications filled out and turned in. And, yeah, but I think overall it was a good process.
Go ahead.
Hi, I'm Betsy Jeffries Perry. I have to say Kelly was awesome at just in making sure that everything was there, shooting emails back right away. So like that, she was our saving grace for every single and making sure we had everything ready to go.
She's a rock star.
Yeah.
The other thing related to that, I'm thinking, to both your points about being able to review the applications ahead of time, and also to Kelly's point about having enough leeway so that we can help, as I'm thinking that we really need to, our next question is when should they be due? And I think we really need to build in a timeline that gives us more time to do those reviews and do follow-up questions if we have them, things like that, before we're in the budget committee meetings. So with that being said, what are we thinking in terms of when applications should be back? In my head, I'll throw out sort of what I was thinking is that we're going to need to approve these in January. So I'm hoping we can maybe do that in the first meeting of January to officially approve the guidelines and the applications. And so I'm thinking if we could have applications available mid-January and then have them come back to us late February, first week of March. That would give the review team maybe about 2 weeks to do a review, and that would give us about 2 weeks roughly before the budget committee. I think we'll start the first budget meeting on April 1st. So it'll be that next week that we would be taking up the grants.
And that would give
applicants about
community
6 weeks.
That's the idea.
Lori doesn't look like she likes that.
Are you talking about all 3 grants or just the operational stuff?
So the capital investment and the operational would be at the same time because those need to go through the budget cycle.
That's going to be difficult for the one I'm thinking about, but,
Special projects comes later,
yeah.
so
But
it's not tied.
this is still a guideline for you. You know now what you're going to need to put together. So you really don't have just 6 weeks, but I mean, from today, you know pretty much what we're going to be asking for. So
Well, maybe I'll, everything will work, Lori.
I know you can do it.
The other thing that we had talked about that I think hopefully with this timeline would allow is, and maybe get some feedback from the audience on what you think would be helpful, is having staff, and probably me most likely, just make ourselves available, like come to, say, since we're in Arlington, I'll use Arlington as the example, but basically set a work session where people can come and bring their applications to us and have us do an initial review, or if you have questions on what you should be putting in the budget, all of those kinds of things, so that those questions aren't coming to Kelly the day that it's due and you're trying to figure out what numbers you need to plug in. And so I see some nods on that I wanted to see. Is that helpful?
That's what it would be.
Okay, so I'm thinking we would probably look at February. I think most people, there may be some eager beavers who get on it in January, but I'm guessing February is when you guys are really going to start dialing in on your applications. So I'm thinking maybe February, we could schedule some of those and walk through them with people.
So what are you thinking of as the deadline for applications then?
Good question. Let me look at the calendar. I'm thinking right now, maybe first week in March. Because that would give us 1, 2, the review team had those done by, say, the 23rd. That would give 2 weeks, basically. So, Kelly, Is it better to do that on a Friday or midweek?
You know, it doesn't really matter.
Okay.
Anyway, yeah.
Well, let's give folks a few extra days.
Right.
And say March 6th.
And then, so how long do we have to look at?
So with March 6th, I would think that if the review team could have their recommendations wrapped up by March 23rd, which is a little over 2 weeks, we would get those on the 23rd, and that would give us 2 weeks and 2 days before the budget committee would take those up.
Well, I was thinking it was April 1st, when's the first?
Well, April 1st is our first,
Oh, we just.
when he walks through it with us,
But it'll be
but the details will be on me.
good, I was getting nervous. That's-
Yeah.
That works.
That'll work for you guys, so that'll give you about 2 weeks to read them and follow up.
Good.
Okay. Okay, so we've decided March 6th for deadline. And any additional questions, concerns on this one?
I did want to note in the scoring on the proposed grant cycle, it proposes adding, and I've got my own paper in front of me now. It proposed adding a score for the sustainability
Oh,
plans,
yeah, that's correct.
changing the percentages and the scoring there.
So here's the question, do we actually want to score the sustainability plans? I'm kind of leaning towards not adding that as a scoring.
I don't think so.
I think it's a requirement to be eligible, but not necessarily something that we need to
Yeah, I
score.
don't think it needs to be in the scoring process. I think we want it because we want people to be looking at that and understand where we're trying to go, but I don't think it should be
Part of the scoring. Okay.
Because how do you judge that? I mean, how do you?
Because
score
again,
that?
there's going to be some people who,
Right.
just in the nature of what they do, are not going to be able to
Not
do
every
that.
entity is the same.
Yeah.
I had a question.
Okay.
You've built in some time for us to ask you questions as we submit the application, but I'm not seeing anything where if you had questions where we have an opportunity to weigh in on, maybe we missed something or you're making assumptions that may or may not be in the application, this kind of thing. Is there an opportunity for you to ask the applicants?
Well, I think it's built into the timeline so that the 2 weeks that we have it basically before it comes to the budget committee, I think it would be incumbent on those members to reach out individually. One of the reasons we used to have sort of everybody come in and you get your 3 minutes or 5 minutes. One of the things that I think we've tried to eliminate is that very thing, because you're at a disadvantage if you can't get off work to come plead your case to the court. And so the idea was that we want to standardize what we're looking at. If there are holes in the information, then either staff will follow up or the budget committee members can call those contacts individually and say, I just want clarity on this piece. But I think we want to try to avoid having folks coming in to plead to the budget committee because it really makes it difficult. It is, not surprisingly, it is difficult to say no to the person who's sitting in the room, basically pleading their case. And those who are not able to plead their case don't have the same advantage, basically. So I think we're trying to build that in with the timeline so that we can individually follow up. Is that fair?
Sorry, if we don't hear from the review committee during that 2-week period of time, does that mean that, or would that mean that applications look fine and perfect?
Or complete.
Yes.
Or complete.
Yeah,
Well,
yeah.
Yeah, and that's Kelly's role in
Yeah.
reviewing them before they ever go to the committees to make sure that everything is there, so that they don't have to ask those questions.
But I'd like to know, if it's not complete and you turned it in at the last minute, there's not time to fix it.
Right.
So,
I guess when I say complete, I meant that you understood everything and that you didn't have a question, meaning, what exactly did that mean if we, put something in there that you just didn't quite
just
understand?
for clearance.
Yeah.
Do we have a list of like last year's operational grant applicants?
Somewhere in this.
I was trying to pull it up, but I don't know why.
I'm sure there's something.
I had a question, but I want to look first.
It's here somewhere, I'm just trying to. Operational grants, that shows requested and approved.
So I have a question about, when I was looking through the application, it talks about, additional information that is required, I believe, is a business plan. And I was just wondering if some of the special districts or some of these entities may not have a business plan. And what do we do if they're an entity that doesn't really, that's not really applicable for them? Is it like, oh, we don't have a business plan, so?
No. So, I guess that would have been a question too. I think people were wondering if it's saying that business plan meant the sustainability plan too. Was that the same thing or was it something completely different?
I thought that said it's available previously.
So that's something we probably want to clean up. For the actual application, because I did not realize we would have such a robust discussion, which is awesome. So what I'm thinking we're probably going to end up needing to do, because we do have a hearing that we have to hold on time, is that we will probably get as much as we can done today, and then on the 8th, go ahead and schedule a longer work session where we can dig into these, and that will also give us some time to think through an outline of expectations for the sustainability plan.
And because the other sister's business plan doesn't say if it's applicable to those entities or, right? Yeah, because
And that could be easily added.
Arlington Health doesn't have a business plan.
We don't either.
Yeah, the library.
Oh, the library.
They just told us that's okay if you don't have one.
Yeah, I thought to be clear.
Yeah, if it said that would take a lot of pressure off.
Yeah.
Okay, thank you.
So let's, let me see what we're doing on time here. We've got about 12 minutes left. Why don't we get started on the capital improvement or capital investment, and then we can take this up again and we can dive into the applications next time. So getting some general guidelines I think will help me. Okay, so I think let's go on to the next slide. We'll skip the recap since you guys are aware. Again, are we comfortable with the list of eligible entities? These are the same that we just approved for the operations funding.
Yes.
Okay, so no changes there. The match on this one was 35%. Do we want to keep it there?
How did everybody do with that?
I think it was fine.
Yeah, there wasn't anybody that didn't have enough.
That had an issue. And then, again, based on the total percentage of the, or based on the total, 35% of the total project cost, correct? Yes. All right, anything about how it may be used? Certain equipment purchases, supplies and materials, contractor costs.
Did that line up with what people were looking for in a capital investment?
I think so. I mean, for the most part,
John says yes.
yeah, I mean, the things that we were funding were, the things that we funded the last cycle were full school districts had upgrades to their buildings. Neither of them expressed any problems about that being too restrictive. And then we just funded the ELS request for their HVAC system. So, you know, and I think we would treat, to Rod's question earlier, in terms of contractor costs, things like that, I mean, I would view that more broadly to mean, you know, if you've got consultants who are looking at, you know,
Because they're.
specific issues, land use planning, things like that, would all be wrapped up into that kind of project. Okay, any changes there?
No.
All right, let's go on to the next one.
Now
Any-
this says.
No, that was for last year's. We're one more ahead of you. Do we want to alter anything about the scoring criteria?
I'm caught up, I know.
This one we did a little bit differently. We did 60% benefit to the county, which is consistent with the other one, but we gave a little bit more weight to matching funds. I think because we were requiring more matching funds, we wanted to see county funds being used to leverage outside investments on infrastructure, basically. And because frankly, there are more funds out there for a lot of those kinds of things than some operational funds. And then we also talked about the timeliness or necessity of the county funding. So the idea if something's ready to go and all of the other grant funders are lined up and you just need us as the last piece, that those funds be prioritized over somebody who's maybe just starting to do their fundraising, because we have a limited pool sometimes on how much we're giving out. So, does that look good?
Yes.
Okay. This one looks a little different. I think we've got about a couple minutes to maybe start thinking about it. We may want to circle back to this. Last year, we used 2 grant cycles. So we did a spring and a fall. And what ended up happening, what we had originally envisioned was that we would make those funding decisions independent of the budget committee in the spring cycle. That really didn't happen. They came through the budget cycle with the rest. And I personally thought that was helpful to have the budget committee members weigh in on that. And then, of course, the fall one came to us independent of the budget committee. So my question is, do we want to continue doing the 2 grant cycles? It's a lot of staff work to do those reviews and manage them. And I personally felt like it was beneficial to have, basically for the operational grants, from Kelly through to the budget committee, there are 10 separate people who are looking at those as they come through before they're funded. To me, the capital grants are bigger grants that we're giving, and so I'm wondering if we want to just marry those and just have one cycle. It comes through in the spring. Budget committee is part of that decision making, and that then it doesn't make the spring any more chaotic, because that's what it is. But then during the fall, that just allows staff to focus on other projects. So we're just doing one cycle, basically.
Can we circle back on that one?
Mm-hmm.
Like the time?
Yeah.
Can the same entity apply in both cycles?
But of course, can't use the county funds to match.
Right.
Yeah. So, okay, so I'm thinking we've got 5 minutes. So special projects, I think we can dive into even later into the year, since those applications aren't due until April, I think is when we normally have them due. So I think, yeah, they opens April 15th for special projects. So we have more time on those.
We
So-
need to concentrate on what's coming up.
I think so too. So applications due the same date as the operational funds, which was March 6th. We'll circle back on the 2 grant cycles question, which will also feed into what the application process should look, or the review process should look like. So I think we'll hold off and tackle those together. Any questions or concerns that came up on this cycle that as you've heard, we're going to reopen the discussion in another work session to dive into the specifics of this, because we've just run out of time. But is there anything that you want to put on our radar that we should be thinking about?
Go ahead, no.
Can you apply for 2 grants, like an operational grant and a special needs grant? Because you got 2 different things going.
Yes.
Okay.
Is that something totally different?
Yeah.
Okay.
Yeah, we treat them as 3 separate applications, 3 separate, so entities can do that. Go ahead.
I don't know if I missed when the applications are going to be out for us to get online.
So
Did I miss that, or?
that depends on if we are able to wrap them up on the 8th, which is our next regular court meeting. So my hope is we'll do a work session in the morning and then be able to pass them. So assuming that we're able to work out all the kinks and get them passed, I would think probably the week after the 8th, they would be available.
You're talking January?
Yeah, January.
Okay, so I can just call Kelly.
Exactly. Kelly's your gal. If anybody needs a takeaway, that's it. It's like, if you have questions, please call Kelly. You're obviously always welcome to call the court's office as well. But Kelly's the one that actually knows what's going on, so.
Thank you. I guess I just missed that date.
Yeah, well, it's in flux just a little bit until we get it finalized, basically. But that's the hope, mid-January to have it. Anything else that we should know about? Any concerns when you're filling out the application? Was there anything that was unclear? Nothing.
I guess mine would be, would the sustainability guidelines be up January, whatever, we put the rest of the application online?
That would be my hope, is that we would tackle those simultaneously.
We need to make a move on that.
So application is a work in progress.
It's a work in progress. Okay, so I'm going to, so that we have just a few minutes before we start our regular court meeting, I'll go ahead and adjourn the work session. It's 9:57. We're going to come back into regular session at 10 o'clock and we'll start with the hearing on waste management. And so I think we all need to reset. And just a few minutes behind schedule, it is 10:04, and so I will call this meeting to order. The chair notes that there's a quorum present. We'll do the flag salute. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, 2.0, we'll do additions, revisions to the agenda. I've got 2. I'm going to be pulling 7.3 from under new business. The sheriff's office has some suggestions for improving that policy to work a little better with some of their unique needs. So we'll bring that back on the 8th to pick up. And then I also, I'm going to go ahead and put it under unfinished business just for, as a courtesy to Waste Management, since they're here for the review hearing. They also are due for their quarterly update. So I will just kind of do a 6.0-A or something and put Waste Management review up front under unfinished business. Any other additions or revisions to the agenda? Okay. Correspondence and public comment. I don't have any correspondence. Public comment. Individuals wishing to address the county court may do so at this time and at other times throughout the meeting. Speakers are asked to raise your hand to be recognized by the chair. Give your name and address. Limit comments to 3 minutes. We'll have plenty of time going in, and obviously we're doing a review here shortly that'll have its own sort of public comments, but anything just generally before we dive into the review? Nothing? Okay. We will go right on to 4.0, which is a public hearing. Today's proceeding is a quasi-judicial public hearing. This is the time duly set and advertised for a public hearing in the matter of a periodic review of waste management disposal services of Oregon Conditional Use Permit 2019-05 for Columbia Ridge Landfill and Recycling Center. The hearing is now called to order. The public hearing will be conducted as follows. Staff will give their report and answer any questions from the county court. Following the staff report, the applicant will have time to present to the county court. I will then open the hearing for public testimony. We'll start with the proponents, then opponents, and then any neutral testimony. After the opportunity for public testimony, the county court may have additional questions for staff. The applicant, Waste Management, will have an opportunity for last rebuttal. The county court will then decide whether to close the hearing and deliberate the matter. When you testify, please state your name and address for the record. Please keep your testimony concise and relevant to the issues before us this morning. There's a clipboard going around, so please make sure that you sign in. All testimony should be directed towards the county court and not to other members of the audience. And I think we'll probably allow up to 10 minutes for those who aren't the applicant, who want to have testimony. The applicable criteria are listed in the staff report. These are the criteria the county court will use to make its decision. If you believe there are additional applicable approval criteria, please identify such criteria when providing the testimony. Failure to raise an issue with sufficient specificity to afford the county court and all parties an opportunity to respond to an issue may preclude an appeal to the Land Use Board of Appeals based on that issue and may preclude an action in circuit court. Failure of the applicant to raise constitutional or other issues relating to conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Additional rules and procedures for the hearing, there's a list over there on the sign-in table so you can see all of the rules. Are there any questions? All right. At this time, I would ask the members of the county court to disclose any ex parte contacts, biases, or conflicts of interest a member may have pertaining to Waste Management's conditional use permit. If so, please indicate the nature of the ex parte contact, bias, or conflict of interest and indicate whether you intend to participate in or abstain from the hearing. Does any commissioner have a conflict of interest that they wish to declare?
I do.
Okay.
I have a conflict. My husband is an employee of Waste Management, so I will refrain from any further participation. This is in accordance with ORS 244.120. May I be excused?
You may.
I will sit in the audience.
Okay. Sherry, any conflicts?
No.
Claire? Okay, I do not either. So we maintain a quorum, so we can do that. Does any commissioner have any ex parte pre-hearing contacts to declare? Do you have any?
I do not.
Okay. I have one that I need to declare. I had a conversation with Dave Lowe several weeks ago. During the conversation, it wasn't related specifically to the review, but there were issues that were raised, including energy generation and those funds being used potentially to support our local chambers and things like that, that are related now, I realize, to some of these things. That does not, yes. Obviously, we need to maintain a quorum, so, and that does not impact my ability, I think, to hear the testimony today. Does any commissioner have any bias in this matter?
No.
Hearing none. Is there any other reason a commissioner does not believe they can participate in these proceedings?
No.
You good? Me either. Does anybody in the audience wish to challenge the ability of any member of the court to participate in these proceedings? Okay, hearing none, let's move on to the staff report and questions. Staff will now present the staff report and any correspondence on this matter other than those items already included in the record. Good morning, Michelle.
Good morning. All right. All right, waste management, I'm going to just refer to it as waste management, Waste Management Disposal Services of Oregon.
It's a little cleaner.
I'm going to keep it a little short as I go through this. So Waste Management was issued a conditional use permit back in 1987. And everything in our review is based on the premises of their initial application. And built into that, those conditions back in that time, it was decided that there would be a formal review process. And I would just like to point out, this isn't always, not all conditional use permits have that. So this is kind of unique to waste management in that there's a formal review and it's supposed to be conducted every 5 years. When you start with the, so we'll start with the staff report. Gilliam County Planning Department staff report, proposed findings and conditions for approval for waste management disposal services of Oregon conditional use permit periodic review as prepared for the county court, and this was prepared and distributed on December 11th. It had to be out and available 7 days prior to the public hearing. The file number in the planning department is CUP 2019-05. The applicant is Waste Management Disposal Services of Oregon. What we're referring to is approximately 2,000 acres that was purchased back in 1987-88. This facility is located off the Cedar Springs Road, approximately 10 miles southwest of Arlington. There are 2 tax lot numbers assigned to what is referred to as the footprint for the landfill, and those tax lots are 1101 and 1103. Today, the reason for today, or the emphasis of having a conditional use permit, is the land is zoned exclusive farm use, and so when you have something outside of the regular normal, you have to go through a conditional use permit. The state of Oregon does allow for the siting up a regional solid waste landfill to be located on exclusive farm use land. And so back in 1987, this is where everything came about when we started with the conditional use permit process. And so today, here we are to review. Today's proposal to review, modify, and clarify the existing conditions of approval as required by condition number 1 of the conditions of approval adopted in February of 2012 in conjunction with the conditional use permit 2011-01 and Planning Commission Order 2011-01. And then the subsequent Gilliam County Court Order of 2012-01, which again was approved and finalized in February 15th of 2012. The appropriate notice for this hearing has been provided to the Times Journal and to adjoining landowners. There have been previous reviews or approvals provided to Waste Management. The most recent was done in 2012. There was a review done in 2010. There were changes or amendments done in 2008, 2006, 5, 2004, and then we go back to 1999. And then there was a review in 93/94, and then 1988 and 1987. So in 1987, when the conditional use permit was originally issued, Waste Management was given the direction that certain things needed to happen within a prescribed 1-year period of time. So that's where we went from 1987 to 1988. And so some subsequent reviews were provided with that. And then we kind of rolled into some regular reviews. Not all the reviews have been on a 5-year cycle. Some of the reviews have happened as a request from Waste Management. Specifically in the 2004 to 2006 timeframe was the period in which Waste Management came to the county requesting an amendment to their conditional use permit for increased height and changing the way they were doing the facility. And so that's why some of these years don't match. And that was a culmination of several years. There was a process that started, and then they realized that a review was due, and then they realized that an amendment request was put in. All of that, so that was in that time frame again of 2004 to 6. There was minor footprint changes, there was modifications to the base grades and excavation of side slopes, and then modifications to the final grades, which increases the height. Now the landfill, all that went through the Planning Commission, all of it went through the county court process and was approved, and they moved forward. And then there was just some subsequent reviews after that period. But that was the most significant time frame that has been had an amendment regarding this conditional use permit. I'm not saying that the other things aren't important, but that was the biggest and largest amendment period of time that's happened in these since the 1987 issuance of the permit. Okay. So for those that are following, I'm on page 4 now of the staff report. And for those in the audience, there are a few copies on the table over there. The proposed findings for the Gilliam County Zoning and Land Development Ordinance and Comprehensive Plan Criteria and Standards. So this is, the state of Oregon has said there are prescribed uses that can be allowed on exclusive farm use. There's probably a 5-inch binder in the planning department. and most of that 5 inches regards exclusive farm use land. And so it's very highly regulated by the state of Oregon. There's only a little discretion that the county can even impose when it comes to exclusive farm use land. So when I'm referring to the comprehensive plan and the land development ordinance, this is the stuff the state of Oregon has told us that we need to adhere to and make sure that anyone that applies a conditional use permit can meet these criteria. So in 2019, we're still reviewing what was said and put in place in 1987. So we evaluate and make sure that they're still in compliance with that. And based on those criteria, the planning department and the planning commission for as far as this refers to exclusive farm use. And the biggest concern for exclusive farm use is that conditional use will not adversely impact or substantially deviate from the farm use in the surrounding areas. My staff report from page 4 through page 11 documents that Waste Management's doing that. They are not adversely impacting the farming nature or the culture around the area. In fact, since 1987, Waste Management has been very judicious in acquiring additional lands. So the original purchase they had was about 2,000 acres. Granted, the 2,000 acres is not the entire landfill, it's about 700 acres. So in addition to that 2,000 that was purchased in 87, subsequent years they've purchased several thousands of additional acres. These acres provide additional buffer to additional landowners for the farming community. And in addition, those acres are at this time still being farmed or utilized for range. Waste Management, I believe, has some lease agreements out there with some of the local landowners so that they can have their cattle and sheep and operations. They can use the land for ranging and farming and agricultural purposes. So since 1987, they have been a very good steward of preserving additional land and working very well with the farming and agriculture in Gilliam County. So from page 4 to 11, that just substantiates that they're doing what they're supposed to do. They're not creating an adverse impact to the agricultural community. So I'm going to move to page 12. If that's all right.
I'm okay with it. I read it last night, so.
Just to clarify, for the record, the staff report is entered into the record, and so it becomes a permanent document for the county court, and so if anyone wanted to request it, it is documented, even though I'm not going through word for word, it is a document that's entered into the record. If we went through this word by word, we'd be here all day, and I don't know that anyone wants to spend that much time. So I will try to keep it as concise as I can and yet answer any questions that come up. So moving to page 12, when a conditional use permit is issued, the jurisdiction that's applying that authority can impose conditions. So over the years, several conditions have been applied to Waste Management. The current number is 23. Today, after the Planning Commission has met and had their hearing, which was on November 26th, they are proposing an additional condition, condition number 24, so that's being proposed to the county court. So compliance review of proposed findings in support of the current conditions of approval as adopted February 15th of 2012, and further recommended for approval by the Gilliam County Planning Commission November 26th of 2019. The 2012 conditions are listed below in bold print. And I put after that the 2012/2019 because we've also added the condition that's being recommended from the Planning Commission of number 24. Waste Management conditions of approval in their entirety are found as attachment D, including the proposal for the addition of condition number 24. Waste Management provided responses to the conditions of approval as submitted on November 12, 2019. In a response to a letter that the county had sent that was dated on September 19th, 2019. Waste Management responses are incorporated below in the staff report. Gilliam County Planning Director has provided comments or findings which are listed below and immediately follow the Waste Management comments responses. Gilliam County Planning Commission has further provided comments that immediately follow the Planning Commission staff report findings. I'm going to preface To effectively move forward with this compliance assessment originally due in 2016-17, the periodic review has been divided into two components. The first component would be to assess if waste management is in substantial compliance with the 2012 conditions of approval from 2012 to 2019. And the second component is to review and determine if amendments are required to the conditions of approval. The phasing of the periodic review, while uncharted territory for the Planning Commission, has been successfully navigated, whereby the Planning Commission is providing a recommendation to find waste management is in substantial compliance, subject to proposed condition number 24. This additional condition would support the approach to the second component of this review in the year of 2020, and would specifically look at improvements to the existing language of the conditions. It's important to note right here that Waste Management is in full support of this approach, this phased approach. Any reference to the attachments listed in the below conditions are not included at this time. And what I mean by that, the conditions number 1 through 23, they were adopted and approved in 2012, and the attachments are not relevant at this moment in time because we did not tweak those conditions. So we did not bring any of those attachments forward. Some of the attachments are not applicable at this time, but the focus was, are they in substantial compliance? And we did not tweak on the language, and we did not. So it refers to attachments because we did not tweak any of the language of the existing conditions as written in 2012 for condition number 1 through 23. And that is as proposed in this phased approach. So that's why I just wanted to clarify, if you're looking for those attachments, they're not there, they never existed, and so that's why that was prefaced right before that. All right, I'm gonna pause for a moment. Are there any questions so far?
I'm good. Sherry?
No.
Okay. So the first condition of approval, and does court wish me to read the entire condition and then provide a summary, or do we just kind of want to summarize and move forward?
I think we can summarize.
Yes, please.
Okay, so
We've read it all. We're aware of what it says.
So condition number 1 pretty much says that this is the stipulation for the 5-year review. It says that Waste Management will provide written notice to the county prior to the 5-year review. I think it's 6 months notice, and they've done it. They provided compliance, it's documented, they did that review. The county has not fulfilled the review requirement. Technicality, there is no deadline for the county to do this. Understand that Waste Management did their part leading up to 2016-17, and it's just taken some time. But we're moving forward, and now we've got a phased approach to try to get this done more expeditious, as it was taking a little time on staff's part to get this done. So condition number 1 has been met as far as the compliance and for waste management. Condition number 1 also refers to some operations and so after the Planning Commission, it says, noted there is additional clarity that it needs to be provided for this condition. For example, what is the definition of substantial? There was no additional discussion on this matter at the Planning Commission level. It's a very elaborate condition, and you're going to find that moving forward that a lot of these conditions are very elaborate and very lengthy. And so to try to compartmentalize and try to figure out exactly what the intent of the condition was a bit of a struggle from both the county's perspective, staff, and from Waste Management. And so we came to a bit of somewhat of an agreement of how to move forward and how to assess for compliance of these conditions. Recognizing that in the phase 2 approach, that wordiness and stuff would be reviewed. Both parties, the county and Waste Management, acknowledge that some of this needs to be tweaked and more concise and provide boundaries and very measurable standards of what we're trying to achieve from a compliance review. So really there was no anything exceptionally outstanding for condition 1. Waste management notes they have started a night shift now. They've done that in the several years previously as well, and so they're just pointing that out, that that's a new change. There have been some additional structures that have been permitted out at the facility, and that was noted by staff. And so, to summarize, condition 1 we feel is met, and so we're moving forward. Condition number 2 refers to, and I'm just going to read it because it's one sentence. Condition number 2 is the 2016 review. The review of this conditional use permit in the year of 2016 shall not be completed until a new host fee agreement is in place. So obviously this condition as written today is not applicable because it's 2019, and this in phase 2 would definitely be revised to reflect current, or if it's even necessary. Where we are with this is in 2016, Waste Management representatives and the Gilliam County Court negotiated and combined 2 agreements. And so a host fee agreement was combined with a road use agreement. And so that was executed and done in 2016. So essentially they are in compliance, but now condition 2 refers to a commingled agreement now in 2019. And so after the planning commission, we just noted again that we would want to bring in under the phase 2 approach to bring this up to make sure that any old references are removed and made applicable for future and what is necessary. So 2016 would be edited. So condition number 3. This is if anything is done at the legislative that preempts county authority. Nothing has happened down in Salem. Nothing has happened at our capital to have to execute this condition. So we've just noted the findings. And in some of these conditions, you'll see that staff says the Waste Management does not have a response, because in the letter that was sent in September to Waste Management, staff already knew that there was an answer. And so we didn't ask Waste Management to provide a response. So that is noted, so it doesn't look like they were just picking and choosing what they were responding to. There were a few conditions that they weren't even asked to comment on because staff already knew the answer. And they were already in compliance. So it was a non-issue. Condition number 4. Condition number 4 refers to a buffer, and that the applicant will maintain an adequate buffer area as described in the 1987 application. Bottom line, they meet the buffer as best as I can determine of what was reflected in 1987. In 1987, again, when I mentioned they purchased approximately 2,000 acres, it was noted with the assessor's office that a certain amount of those 2,000 acres had to be disqualified from farm assessment, special farm assessment, because those acres are no longer going to be farmed. And so it's a process that has to happen, and so that process did happen back in 1987. It was approximately 700 acres. Between 1987 and 2019, and if you look at all the different reviews, this figure has changed, and it was documented around, for the footprint of 500 acres. This will get into another condition, but I'm just trying to go back to focus on with a buffer. So back in 1987, approximately 700 acres was, at that time, supposed to be removed from special farm assessment. Everything outside of that 700 acres was deemed the buffer area. In subsequent reviews, and even in the letter that Waste Management provided to initiate and kick off this review in 2016, they provided a map. And since 1987, Waste Management, like I previously noted, has acquired several additional acres that surrounded that 2,000. So this map that they provided in 2016 shows the area of the 2,000, and then 3 sides, because Waste Management is predominantly the 2,000 acres is all on the, it's going to be north side of Cedar Springs Lane. And so 3 sides of that is all additional land that Waste Management, for the most part, has purchased. They haven't purchased a lot of acres that crosses Cedar Springs Lane. So with that additional acres, this map documents that around that 2,000 acres, they kind of drew a line that's about 1,000 feet. This would be a discussion that Waste Management and Gilliam County would love to have in the phase 2 of defining what that buffer area is. That map is, staff really likes that map because it provides something that's detailed and measurable, and we can say, okay, this is 1,000 feet around this 2,000 acres, and then 2,000 acres is isolated to one tax lot. So it can be very quantifiable and it can be documented, whereas the buffer for 1987 is just more fuzzy and just outside of the 700, which is a very random polygon that's kind of in the middle of these 2,000 acres that were purchased in 1987. So to summarize, they are in compliance with the buffer. In phase 2, staff and I believe Waste Management would like to define that more. What is that? Is there a document we can enter into the record to say this is what it is, and moving forward, this will be the map if it needs to be tweaked, and this is how it's defined. So as far as 1987, because this specific condition actually refers to 1987, they have met the buffer. Condition number 5 is expansion. So condition number 5 is kind of what I alluded to under condition number 4, where we're talking about the footprint and the 500 acres. And so as of today, in 2019, and per the assessor's office and a letter they had further sent to Waste Management, there was some additional things that were being reviewed, and I think Department of Revenue. So long story short, today the assessor's office has 72 acres disqualified from farm assessment. And so staff's just kind of summarizing how I stumbled and through the research of going through the files of this condition refers to 500. All I know is the condition refers to 500. I don't know where it ever changed, because in 87 it said 700 and in 2019 we're back to 700. So things have happened. I'm trying to summarize that and document to the county court that due to whatever happened in the files or through the reviews, that number was tweaked or adjusted, and it may have been adjusted through something with the Department of Revenue, something with the assessor's office, or maybe it was done and we thought it was done and it wasn't. Nonetheless, today we're going with the figure that the assessor's office has. And so this in phase 2, we would update that. We would definitely not want a 520 acres reference there. We'd want the 700.72 because we have documentation today that can back that up. Okay. So that's where we are on that. And Waste Management isn't opposed to that. It was just, are they in compliance with 520? Well, yes. However, we found further additional documentation that says that's been increased. And they have paid all that, so it really needs to reflect what is truly been just happening. Yes, according to the assessor's office. So this is another where it's not just the planning department, but it involves another department of the county to fulfill the compliance requirement. And you'll find that, and maybe you did find that when you're reading this, some of these conditions refer to the county court, some of them refer to the planning department. And so it's a little bit ambiguous of bottom line, who is the compliance authority and who, when a condition might need to be executed, who is to do that execution of that condition. That's something that Waste Management and staff feels we would like to discuss further under the phase 2 of cleaning this up and making it very clear of if there's something that needs to be addressed regarding the condition, what is the outline and prescribed process? And it's well within the county's jurisdiction to define that process, and we can work with Waste Management on that, and that would be something that would come with phase 2. Sounds good. Okay. I'm moving to condition number 6, and for those that are following along, this is page 18. Condition 6 refers to local services and vendors. Waste Management provided a list, and staff does not dispute it. Waste Management makes an effort to utilize the local vendors and services in the area, and so we're not questioning that. We're saying they're in full compliance, and there was nothing to the contrary brought up at the planning commission either. Number 7, condition of approval refers to the landfill operations. This is one of those conditions that's a little lengthy again. It refers to elements of the conditional use permit that aren't necessarily prescribed by the county. For example, it's referring to the erosion control plan, drainage plan, and a lot of these components are actual requirements for the permits through the Department of Environmental Quality that Waste Management has several permits with, and for the siting of the solid waste landfill. Gilliam County's conditional use permit is something here locally, but there are numerous permits they have with the Department of Environmental Quality to keep them in compliance with air quality, emissions, to the soil. There's just a numerous amount of those. So this is a condition of what are we trying to get at? Who is the authority to substantiate and determine whether they are in compliance? Waste Management provided copies of these plans. And so as far as that front and how we're trying to pick apart this condition, they provided those documentations, they're in compliance. The county has not received any information from DEQ to suggest otherwise. And so it was a determination by staff and planning commission that they're in compliance with this one. All right, so condition number 8, this is the road use agreement that was referred to that I previously mentioned under condition number 2. So there was an individual separate road use agreement up until 2016. And at that time, the county court and waste management representatives negotiated and combined the 2 agreements. Again, this is something that did not involve planning department. It doesn't have to necessarily involve planning department. However, it does have an implication to the conditions as written. So the conditions right now refer to 2 separate agreements. However, now it's been commingled into one. So we would want to accurately reflect that moving forward, and that would be something that would come under phase 2. Again, we're not proposing changes or edits to the existing 2012 conditions. Right now, the process is to assess are they in substantial compliance. Okay. So we would confirm that yes, they are. It's a different agreement. It's not a separate agreement, but there is a road use agreement that's still in effect, and it is current as of 2016. It is important to note, which I did mention under the condition number 2, that this commingled agreement has an expiration date of 2025. So that's coming up very fast. So one of the things, that is one of the reasons why condition number 2, sorry to digress for a minute, referred to 2016, is because there was an expiration on the host agreement. And so that's why that specific year was inserted into that condition, because the county court wanted to make sure that before a review could ever happen, that host fee agreement was renewed prior to this process. And there have been some times when the reviews that the host fee agreement, it took some more negotiations than anticipated, and so the review got a delayed start. So that's why when you're referring to some of these dates and inserting specific dates, it might not be as noticeable and explanatory of why it was in there, because by condition number 2, you had a reference to 2016, but it doesn't say why. Well, the reason why was because the host fee agreement was expiring. And so I just wanted to throw that out there because I wanted to bring it to the court's attention that some of these subsequent agreements or arrangements that trickle down from the conditions do impact the conditions, and it might not be apparent sometimes when you're moving forward. And I know that this is the first review for this county court, and so I just wanted to kind of point that out. So they are in compliance with condition number 8. Condition number 9 refers to a citizen advisory committee. The county court has established a citizen advisory committee, and the citizen advisory committee is according to Oregon administrative rules. It refers to 459.320, and it gives you an outline of who should be involved and who should sit on that committee, and kind of what the purpose and the goals are for that citizen advisory committee. The county established this way back at the beginning of the on-site of the solid waste landfill. It's still in existing at this moment in time. The way the Citizens Advisory Committee has been staffed in the past has varied. There have been times where Gilliam County staff has been the entity that has provided the notice and sent out the notices and did all the minutes and correspondence for that committee. And there's a clause in there where, I don't know if it's this specific condition or we get into it under condition number 12. But it refers to the county can get reimbursed for those expenses. So at a period in time, the county was doing all that staff for the Citizen Advisory Committee, the CAP. And at this current present time, right now, Waste Management is providing those notices, they're emailing out, they're mailing it to the members, and so there isn't a reimbursable right now because Waste Management is providing that in-house. So that's where some of that connection is. Some of this has changed throughout the past, so I just wanted to point it out. We do have it. The committee has always been in existence since the landfill came around in 1987 and was approved. Just the way it's been managed and administered has changed throughout the years. Okay, so the finding is that they are in compliance with that condition. Condition number 10 is another, this is a very, very lengthy condition. Bottom line, it refers to ownership transfer, and this has not been executed. There has been no change from Waste Management's ownership at this time. So, condition number 11. Condition number 11 refers to the Seattle and Metro contracts, and that Waste Management is required to meet with the county court 6 months prior to the time the Waste Management contract or Metro contract goes to another site to discuss any adverse impacts which may occur as a result of the potential loss of jobs and revenue. This is one of those conditions that, again, is specifically calling out the county court and the county court's involvement in helping execute or follow through with this condition. So the planning department, since my tenure and being here in the planning department is aware that these contracts have been renewed and Waste Management has provided that in their response. Did the planning department have an active role in that? No. Did the county court? Absolutely. And did Waste Management come to the county court and express to the county court, especially with the Metro contract? Yes, they did. And were measures taken? There was yes, there were. There were people from the local community here that went down to the Metro Council and provided presentations and comment down there. We had, there was that trash video out there. There was legislative or lobbying, for a better word, Metro Council from representatives from Young County to make sure that we were representative during discussions. Waste Management and the county hosted Metro councilors and had a tour out here. And so, again, this is for compliance. We're referring to the county court, and the county court having a very active role in this condition. So there's been a little disconnect. Planning knows that things happen, but as far as the exact and all of that, does the planning department need to know? Do we have to know? Those are questions that the county court would have to decide, but from our assertion and from the Waste Management response, this condition has been met. Condition number 12 refers to communications. And specifically, it's referring to the Citizen Advisory Committee and that meetings will be held. It refers to that Waste Management will annually, at a minimum, publish in the Times Journal, because that's our local newspaper at this time, who that local individual contact living in the county and their phone number. So if a concerned citizen wanted to talk to someone directly, there is a published notice in the Times Journal. And then it refers to having communications with our local governmental bodies, and it specifically calls out the Gilliam County Court for quarterly meetings, the Arlington City Council semi-annually, Condon City Council annually, and the Gilliam County Planning Commission annually. And so at the time of drafting the staff report, I as staff did not request from Waste Management documentation that all of that was fulfilled for the period of 2012 through 2019, when it was a very lengthy period. However, subsequently at the Planning Commission hearing, a very thick folder was provided to provide all that documentation that was meant by Waste Management. So they did present that and enter that documentation into the record at the Planning Commission hearing. And if anyone wanted to see that, I have a folder right here in the box. But I just wanted to point out, because the staff report says at the time I did not provide or request that stuff, but then Waste Management did provide it at the night of the hearing at the Planning Commission, which was November 26th. So it is entered into the record. So if anyone requests, they can come and can view it, or, you know, for a fee, they can get a copy of those documents if they wanted. So, at this time, we believe, the recommendation is that they're in compliance with their communications. Condition number 13. Out-of-state waste. Waste Management has been authorized for and may continue to accept for disposal at the facility waste that originates or is transported from outside of the state of Oregon. This took a little research, gearing up for this review. I went through several of the previous reviews, and from my assertion and reviewing of the previous files, from what I can tell, there was some proposed federal legislation going on at a period of time that would adversely impact Waste Management's ability to have out-of-state waste. And from what I can tell is the proposal for that language federally was, the loophole, or the caveat was, if the local jurisdiction had something in their conditional use permit or under the regulation for that regional solid waste landfill that would allow them to have out-of-state, then they would not be adversely impacted by that legislation. So, first onset of looking at that condition, one might say, and I ask myself, well, they're doing it, we have a Seattle contract, and what was the impetus? So that's where I can, that's what I was able to ascertain from doing some research and going through the files. I don't know if this is still a huge concern, or if that would be something under phase 2 is this even relevant anymore to have this out of state? It's not hurting us, but I thought it was important to document how we got there and why it was there, because before you make changes, you sometimes need to understand why it was put there to begin with. And so that's what I could figure out. If there was a concern from federal legislation that was being considered at some point in time, and that's why this was added to the conditions of approval. So obviously they're in compliance with that, and the county's okay with that, and Waste Management is okay with that. So condition 13, we're good. Condition number 14. I'm going to pause just for a moment.
You're doing well. It's a lot.
It is a lot. Okay, condition number 14. This is a very interesting condition, and I'm just going to say that the county and Waste Management knows it is a concern. This refers to open top containers. Hopefully when you read through the staff report, you found the reasoning and the definition provided from Waste Management, which staff and myself, I thought I was very compelled, and I really understand the reasoning behind the explanation that they provided for the open top containers. On a technicality and a wordsmithing, do they have open top containers? Yes. The response provided from Waste Management is, or an argument you could say is, open top containers, when this was written, is referring to the containers that are on the trucks, the roll-offs, the 40-foot, 48-foot containers, or that are on a rail car that are tarped, and a container is not a gondola. So today we have several loads of gondolas, which is a different mode or different vehicle that's used on the rail, and it's only used on rail or by rail that's transported into the facility. And the waste product that is in a gondola is what they refer to as dirty dirt. Some of that can be from construction projects or debris or your sludge, and it's nothing harmful to the environment, it's nothing harmful to animals or humans or anything, if particulates should blow, which there's measures put in or sprayed on like currently right now Waste Management is using a product, working with the facility out of Seattle, dirt glue. So when this dirty dirt, per se, is loaded into a gondola, then this, I think it's called ground stabilization product, or material stabilization project, is sprayed on top of that. So that forms a layer, so nothing can leave or disperse from the container. Gondolas are not designed to be tarred. They're designed in a way to be unloaded. So they're unloaded at the rail facility. They're never taken off the rail and loaded up to the hill like our containers are when you're hauling in a regular standard rail car or from the trucks. And again, if I'm not speaking correctly, Waste Management can correct me. But it's just, I thought it was a very good definition that they provided. And I don't think it's an out, but I think it's very interesting because back when this was established, remember, this petition was put in around the 1980s, early 90s, and a regional solid waste landfill was very new to Gilliam County. And so there was a concern about odor and debris and what can happen with all this transporting and mass transporting of waste from the metro area to Gilliam County. And so obviously we want the trucks to be enclosed. We want any rail cars to be covered. And so it was established, and we were talking about open top containers, but I think the definition they have provided is well worth exploring. And so in phase 2, I would like to, and I believe Waste Management would concur, to define that open top, either we change this and so it doesn't even refer to open top containers, or we acknowledge that there are other modes of transportation of waste now. We have gondolas, and there may be something in the future that we're not even aware of that may present itself as well. And so this was very specific to containers that were being hauled by truck and by rail as standard cargo containers for waste products at that time. So on a technicality, are the open top containers? Yes. But the definition provided and the information from Waste Management regarding this, the staff and Planning Commission are okay to say, you know what? They're substantially in compliance because they're doing what they're supposed to be doing with waste. And it's important to note that, again, I mentioned, the conditional use permit is just one little permit that Waste Management has. There are numerous permits. And if they're hauling dirty dirt or debris or sludge or construction materials in those gondolas, there are strict guidelines that the Department of Transportation that they have to meet. And so again, Waste Management, we have not received anything from Waste Management, we haven't received anything from the Department of Environmental Quality to say the handling and the hauling of these materials is outside of the purview of what they should be doing. So that's where the assertion that the Planning Commission and staff said, you know, they're in compliance with this, based on the information and everything that we came through in 2019. Condition number 15. Condition number 15 is another very elaborate condition. And again, I know the court has reviewed the response from Waste Management and from staff. And bottom line, again, Waste Management has specific requirements and permits that they have to adhere to the Department of Environmental Quality. And it's very, very specific when you deviate from municipal solid waste and how to handle different waste streams, which we typically refer to as special waste. One of the great examples that Waste Management provided is asbestos. So that is a special waste stream. And there are specific, very specific guidelines and requirements for how you have to process that waste when it's here and how you handle that. It has to be separated and segregated in a certain manner. And so staff is of the opinion that they are in compliance, and so is the Planning Commission. Again, we have not been notified by the Department of Environmental Quality that Waste Management is not in compliance with their permits. And that includes any special waste that's being delivered. I did ask Waste Management, because special waste wasn't, again, this is one of those things that come about with technology and advances, and in 1987 it was municipal solid waste that was being accepted. So I did ask them, I go, can you just tell us kind of what numbers? And so they did before the public hearing on the 26th, provide kind of an assessment for the last couple of years of what's that volume of special waste and how it's changed. And really, it hasn't changed very much in the last 5 years. But it's also important to note that this is another one of those conditions that that can have different implications, especially where the county court is concerned, because the host fee agreement refers to special waste. And there's a different fee structure, at least it was at one point in time for the special waste that's being admitted and accepted at the waste management facility. So I just want to, it's just very, I'm sure you all, the county court is aware of this, but indulge me. It's important just to point out that the host fee now, it's not only condition number 2 that it's reflected, but also under condition 15 too. So there are implications, and again, the host fee agreement has nothing to do with the planning department. This is something that is from the county court's authority and jurisdiction, and with representatives of waste management and legal and whoever's involved. And planning isn't. However, we refer to those accessory or other agreements through the conditions. So it is very multi-layered that we put in here. So that's one of those things in phase 2 we want to definitely define who's authority and who's responsible for carrying out some of these measures. But as far as special waste and compliance, they're deemed to be in compliance. Condition number 16. Condition number 16 refers to the City of Arlington and the City of Condon and county waste disposal. So prior to 1987 and then 1988, when the construction era, everything started with the regional landfill, there were individual landfills associated with the 2 cities in the county. And so it has been very beneficial that we were able to convert those and close those up, and then now we just have a regional landfill here. Through that process, and again, this is something that was negotiated, either it was outside of the conditional use permit, either the county may have been involved, or maybe it was just waste management and the cities at the time. Arlington, the City of Arlington has its own waste disposal pickup services, and that's included under the municipality. The City of Condon contracts out with another company, the Dallas Disposal Company, for those services. Also, one of the components that when you're trying to read through this condition is that residents should be able, or residents are allowed to dispose of waste or solid waste at no charge unless you hit a certain quantity, and most of that is triggered by businesses. And so at the solid waste landfill site here in Arlington, residents can go and drop off their solid waste at no charge. Again, you have your franchise developments at the cities, that there is a fee attached to all of that, and then all that waste is collected and dumped at waste management. There's also recycling components attached to both cities. They're referred to as depots. I know in the City of Arlington's depot here on Cottonwood, that's open all hours. It's not restricted. The City of Condon has gone through different phases, and at this time, for recycling, it's restricted to dates and our day of the week and time specific of when people can utilize those services. And so that stuff's being provided, and there's a lot of different avenues down here at Waste Management for recycling as well. You can have your electronics, you can have tires, and there's certain places that those things need to be recycled. And I know Waste Management has revised or updated their signage for that stuff as well. So that was a long explanation, but this is trying to pick out what the root of what this condition was trying to get at. We closed the current landfills. We have a solid regional landfill, and people can utilize, citizens of Milton County can go drop off for no charge if they drive to the landfill. So they're in compliance with that. Condition number 17. Condition number 17, again, is a very exhaustive condition, and it's getting into the very specifics of how litter control shall be mitigated or adhered to by waste management. This is a condition, Waste Management did provide a copy of their litter control plan, which they are required to have through their Department of Environmental Quality permits. And what I can say here is some of the stuff under this condition, in addition to the condition number 18, they go hand in hand. It's referring to litter, and the condition 18 specifically calls out that there should be patrols for litter. And most of this was prompted by our elusive plastic bags, because they love to get caught in the wind and then they just kind of blow. Gilliam County, in an effort to help mitigate this, has a contract with Norcor, the Regional Corrections Facility, for those inmates that qualify for work release. And so if it's not daily, it's pretty regular that they're out here patrolling the roadways and collecting debris. And so waste management is definitely, there's a contract, so waste management helps fund all that. And so that's a side contract that refers to the 17 and 18 conditions of approval here. And so measures being, and then there's fencing, and there's all sorts of other measures that they're doing to ensure or help eliminate. You can't completely 100% contain it, but you can do as best as you can. And it's been deemed that they are making measures, they are doing measures, they are doing everything they need to, and above and beyond, because the one condition number 18, I think, says twice a year patrolling, and we're doing that almost on a daily basis through the work crew, Norcor, that they're collecting that debris and making sure our roadways are clean and clear. Because just because we have a solid waste landfill site here, we don't want to have garbage seen from the roadways. And it is important also, and Waste Management clarified me at the public hearing. I said, you're not to have any untarped loads when citizens are dropping things off at the Columbia Ridge landfill site. And I said, they'd be rejected. And then he was like, Michelle, we don't want to do that, because now they're going to be driving back down the road with an untarped load, and we don't want any more debris. And I go, good point. So they are supposed to be all tarped. There's notices out there. Waste Management puts fires out, there's publications out there that all those are to be tarped when they're brought to the landfill. And again, they're not going to reject it, which they corrected me on, but we do make a best effort to make sure that everyone's complying, because we don't want any more trash outside of the landfill than necessary. So condition number 17 and 18 are found to be in compliance. Condition number 19. Condition number 19, when I prefaced, when we were going through the review periods, so this was the period of 2004 through approximately 2006. And this is when the Waste Management came in and they got the height increase and the footprint and all those different measures that were pretty substantial at the time. And they came in with a formal request to amend the conditional use permit. So condition number 19 refers to the potential of there actually being visibility of the landfill from, and it calls out Highway 19. So the junction of Highway 19 and the junction of Highway 19 and Cedar Springs Lane. And at this time, so we're in 2019, so approximately 7 years from now, it could actually be visible from Highway 19. Now there's measures that Waste Management are employing regarding how they're excavating and they're creating berms, that it will be, even if visible in 7 years from now, it will be dramatically decreased due to the implication, or due to the measures that they're currently utilizing at the landfill. This specific contract calls out trees, and Gilliam County is not known for trees. Which is probably not a surprise, and so it's very concerning, because again, if you're going to the technicality of the word for word of the contract or conditions, it's going to be very difficult for Waste Management to get trees to grow up at the site. And it was a measure put in at the time. Again, this was back in 2004, 2006, so again, 10 years ago. But however, if you were to plant trees even today, so let's say the condition stands and we're going to go plant trees, they need to plant those trees within like 2 years, because we want those trees to be grown so that they will be able to obscure the vision when the landfill could be visible in 7 years. So it's something that in this phase 2, the waste management and the county acknowledged, we really need to look at this and see what are there better measures, what do we need to do, and we need to do it sooner than later, because if there are plantings or something, a prior to shading or something that needs to happen in a time frame to help alleviate that potential in 7 years, that has to happen before 7 years from now. It's not an after the fact, it's before we get there, we need to put some measures in place. And so this is a condition that really isn't applicable at this moment in time, but it's knocking on our door because it's coming very fast. And Waste Management acknowledges that they would like to work with the county on how can we make this so that we understand what's the measurable standard, and we understand the time frame, and what's going to be, how can we tweak it so that it's feasible for everyone, how we get there. So that would be coming in the phase 2. Condition number 20. So condition number 20 refers to landfill gas collection. The landfill gas collection and clearing system currently in place is permitted as part of the conditional use permit. Any other use of landfill gas at the landfill or transportation of the landfill gas or landfill gas byproducts on-site, including the generation of electricity, requires authorization from the county court. If at any time the existing landfill gas to energy facility exceeds current capacity, requiring an expansion of the facility for the generation of electricity, Waste Management will meet with the county court to discuss in good faith the economics and the potential financial benefits that could occur from the county and Waste Management from the generation of electricity. Okay, that was a mouthful for the landfill gas collection in this condition of number 20. So I'm going to just give you a little background. So again, indulge me please. So when landfill was cited in 1987, it was cited as a solid waste dry landfill. And since that period of time, the time frame doesn't hit me exactly, but I know that there was a period in time where Waste Management so we're talking about innovations, we're talking about new ways of how to more efficiently decompose the waste, and so through a research and development project and application through the Department of Environmental Quality, Waste Management was allowed, and with county authority, was allowed for the introduction of liquids to the landfill. So by adding these liquids, and I'm kind of really dumbing this down, but we have an engineer for Waste Management behind us who can really, if we need more information, but this is my understanding. So we're adding liquid to the landfill, which was originally cited as a dry landfill. The liquid's helping expedite, the decomposing of everything, but with that, now it's producing gas. And so the gas previously has been flared off because you have to do something with that gas. And then through technology advances and everything, now that gas can be converted and channeled into what they're referring to as the gas to energy facility. So they have, I believe, 12 engines in that facility. And this is where that gas is being pumped in and power is being utilized by the engines. And they have authority up to 16 engines in this facility. So this condition calls out that if they start to sell electricity, I don't know, Leah, did you ever figure that out when you guys started to sell electricity?
I did not.
Okay.
Started doing that.
So since the last review, it appears since the last review, Waste Management has actually, in effect, been selling electricity. So this calls that out, and so it calls it out to the county court. It's not calling it out to the planning department. It's not calling it out to the planning commission. So I don't know in the last, since 2012, if there has been a discussion between Waste Management representatives and county court regarding the sale of electricity. I don't know that. What I can tell you is we do know that their electricity is being produced, it's being sold, and it has an impact on the Seattle contract.
Well, it's actually, we're selling that to the city.
City of Seattle buys the power.
So there's a connection. Again, this contract, what I can tell you is, from my understanding of this condition is the time of the county court, and I think this was when our belated Commissioner Gronquist was on the county court, it was, but for you would not be able to produce electricity if it wasn't for Gilliam County allowing you to introduce your liquids to the landfill. So if at that time you actually start making money on it, let's have a discussion. Where that discussion was supposed to go, or what it was, or that if Commissioner Gronquist is just saying, I just want to know, you know, he's not here today, but that's the only background and research I can figure out where this condition may have surfaced from. And so this is something that, yes, they're producing it, yes, they're selling it to Seattle. Is there a direct connection to their contract? I think so. But that's not, again, with the county court, that's with waste management and their contract. But again, this is multi-layered and how it all gets in here, and that the county court is being called out for jurisdiction of this. So, is it detrimental to the review that they're selling power? No. Is it something that needs to be discussed and evaluated and reviewed? Yes. It's a discussion that the county staff and waste management know, oh, well, according to this condition, we probably need to have a sit down. And if that sit down's with the county court or whoever it is, then that probably needs to happen. And that's something that would happen under this phase 2. We weren't tweaking the existing conditions. We were just going through and reviewing for substantial compliance. So this condition number 20 is in those conditions of number 1 through 23 that were written in 2012, and we say they are substantially in compliance. They've been approved by the county and by the Department of Environmental Quality, and their permit is current with them for this research and development project to produce and generate electricity. Where it goes from now and how this articulates with the county court's involvement and where it goes, it's something that I think is beyond the conditional use permit, but it's something to bring to the county court that you're being called out in this condition to maybe do something different in addition. So it's just bringing awareness, and I don't think this falls on the planning department's preview. I think it really comes down to the county court and waste management to work out however it's listed here. So in the best research and what materials and information is provided, we acknowledge there is a further discussion that needs to happen, but we're not going to say they're not in non-compliance over this matter. At least that's staff's opinion. Okay. Condition number 21. Condition number 21 refers to the rail yard operations. The rail yard and related facilities in place and operations consistent with current operations may continue, but any substantial changes in these facilities or operations as determined by the county court shall require an amendment to the conditional use permit. Again, this specific condition is calling out the county court for jurisdiction and authority and approval. Staff does believe in the last 5 years or since the last review, there have been, in staff's opinion, substantial improvements and upgrades at the rail facility. This is again another condition where what is substantial, it is not defined. Waste management, I believe, is of the position. There have been improvements, yes. Are they substantial? Again, so it becomes a wordsmith of what is the determination and how do we define substantial. Have there been improvements? Yes. Staff is of the opinion the improvements have been awarded as capital project improvements by Waste Management. It's been recognized that they have spent significant capital improvements out there for efficiencies and better mobility and movement of the waste to accommodate the rail traffic that they're getting. So with that said, is it detrimental? Staff's opinion is this condition, if we take out the word, we're not going to be to that substantial at this moment in time. The improvements are great. They're acknowledged. It was needed for efficiencies and economics out there, and we're glad that Waste Management was a great steward in doing those things to help us. I will note right here that during the Planning Commission hearing that was held on November 26th, we did have a resident that commented, and that was Mr. Les Rourke, and he's very concerned about the railroad crossings cross specifically at Cedar Springs. He is of the opinion and would encourage that more, that those railroad crossings be incorporated into this condition. Now, that's just one individual's position, and if you further read in the staff report, he did provide his letter, and it's entered into the record, and then the summary of the minutes of the planning commission hearing. So, as far as rail operations, staff and I think Waste Management acknowledged that there have been a lot of improvements done. Was planning department directly involved in that? No. Should they? I would beg to say they probably should have had a more active role in the permitting or some sort of permitting what actually took place at the rail yard. However, when you're looking at the condition, it specifically calls out the Gilliam County Court. So I would ascertain that during all these quarterly reports in the last 5-6 years, Waste Management was very upfront to the county court that all these improvements were being had and being laid out for the rail yard. So were they in de facto, because they were providing reports to the county court, providing and receiving that acknowledgement that they can move forward with that? And was there another maybe element or action that should have been done that involved the planning department? These are some of the discussions that we need to have regarding the phase 2 of how do we structure that stuff moving forward. When there are changes to structures or facilities out there, how is it documented? How is it recorded? Is there a permitting process that needs to be adhered to? Just really defining what is to take place so that all parties understand, and so that we know if there's going to be a structure to say store some of the trucks in. The Waste Management knows up front, this is how we're going to handle any of that moving forward. This is the process, this is the time frame it will take, and so some of those questions are a little vague right now, or the answers to those questions are a little vague in process. So at the end of the planning commission hearing and at the end of the, and then the staff report, staff is recommending that this condition is met at this time. But we acknowledge there's a lot that can be discussed in phase 2 regarding the specific condition and how it may look in the future. Condition number 2, it refers to just applicable laws and permits, and again, Waste Management, nothing has come to the county to say that Waste Management is not in compliance with any of their other numerous permits that they hold. So we find that they're doing just fine regarding that aspect. Condition number 23 refers to the plasma gasification project. This is a condition that's not applicable at this moment in time. Waste Management did have a joint partnership going with a new research development company that was referred to as the plasma gasification project. Waste Management was an active partner in that. Waste Management no longer is a partner in that project. At this moment in time, that building or structure is being leased by a different entity, and Waste Management has severed any ties or connections to that project. So for being applicable and revising this, if we were already in phase 2, we'd say, this needs to go away, because how can they be in compliance with something that they don't even have a partnership or ownership in? So it's really not applicable, but again, we're not changing, in this 2-phased or assessment of compliance, we weren't changing anything between the conditions number 1 and 23 that was being presented through the planning commission and now onto the county court. So at the planning commission hearing, it was uncharted territory for the planning commission, and the planning commission is very, very interested and intrigued with this phasing approach, and specifically the phase 2. As I just referenced through all these conditions of 1 to 23, there's several things that probably need to be reworded, clarified. Is it still applicable? Can it be more defined? What is the measurable standard? Who is the authority that's coming down for compliance? And so our planning commission is proposing a recommendation of condition number 24 to the county court. And so if the county court would, after this public hearing, if the county court is in agreements that substantial compliance is met with the addition of 24, condition 24 calls out that by June 30th of 2020, a review of all the conditions will be done. vetted, and specifically vetted for clarity, measurable standards, rewarding, are they legal, are they applicable? So all of that tweaking would happen at that moment in time.
My question is, why do we need to add a condition 24 to this conditional use permit in order to make that happen?
The planning commission wanted to, so waste management is a fan of this, and so is the planning department, but knowing that I, as staff, had a difficulty time getting this review started, they wanted to kind of put my feet to the fire.
And that's the only reason they want to add a condition 24? I don't understand why that's
For a deadline, yes.
why that's necessary.
It's for a
Why there
deadline.
can't just be an agreement that says that Waste Management and Gilliam County agree that the conditional use permit conditions 1 through 23 need to have a review, and the timeline is to be completed by June 30th, 2020.
There could be a subsequent review. Mr. Rourke actually kind of referred to something like that, and he suggested a memorandum of understanding between Waste Management and the county court that this phase 2 would be, how it would be handled. And he was actually suggesting that it be very detailed in what manner it would be handled and with the deadlines and prescribed. The planning commission didn't want to conform, to get that specific, but they wanted to make sure that with substantial compliance, that everyone understands there's more work to be done, and that the review is not done. In fact, there's a lot of more work, and so that was their suggestion of the 24 is to make sure that that work gets done.
But if we add a condition, then that is part of the record, and then every time it gets reviewed, that condition is in there.
It would actually be written out during phase 2.
I just don't see the point in having a condition 24 when we can just make an agreement that, yes, this needs substantial review and work, and move on from there.
And I appreciate that, because I think that's the objective the planning commission wanted. They just wanted to make sure that the county court was on board with the second phase, and that can be structured in any fashion that the county court deems appropriate. And if the county court wants to just put an agreement or put it on the record that this is what will happen, they didn't want phase 2 to get dropped. Not to say that it would by the county court, because I do believe the county court sees the importance of that phase 2, but they just wanted, that was their attempt. They can't direct the county court to do this agreement, but the county court, you guys have the authority to do that. That's what you like, and not accept 24. You could say,
I don't even see a 24.
It's in the,
Where did I miss that? Page 36. It just says that there will be a condition 24. It doesn't specify what condition 24 really is.
in attachment D.
It is, yeah.
It's out of this.
So attachment D. And
You're on.
it's going to be page 7 of attachment D.
So it's sort of an insurance policy for the
That's what they
planning
are.
commission to
Right.
ensure that we
It is,
circle back and do.
it is within the county's authority, wheelhouse, however, to structure that. If they don't want to do 24 and want to do it in a different fashion, that is completely within the county court's review.
Thank you.
You bet.
Do you have more in your staff report, or wait till more questions?
I don't. This is kind of where we're at. If there's additional questions of staff.
I do have a question about visiting the landfill and seeing some of these conditions that were described. Did the planning commission, did any of the commission members or the staff go to the landfill and actually see these facilities that are being reviewed? Or was it all just a presentation?
The planning commission, not in recent years, has not been to a tour. I know that they have in the past. I did participate in a tour, well, it was with the Metro. When Metro came out, and so I was recently out there on that tour of the facility. And then I had a tour when I first started the position of the facilities. Was the lens during the tour specific to the conditions? No. It was more waste management, showing this is what we're doing, this is kind of what an active cell looks like, those things. So to answer the question of have we done a tour specific to addressing the conditions now. It was a more general tour.
Any other questions for Michelle? We always have the option of circling back if something's triggered. Okay, for now, let's move on to the applicant. The applicant's now given an opportunity to address the county court. Do you guys have anything you want to add, waste management? Michelle cover it. So and you're welcome. We'll set aside up to 30 minutes. I think we've got time. So if you have anything you want to add, or if not, we can move forward.
I think that there's been a lot of work done. I think the idea of going back and doing a second review and sort of reassessing a 30-some-odd-year-old document, I think that's very applicable, and I like the recommendation that's being made, and we look forward to reviewing it with the county.
Okay. Any questions for Lee?
I just had one question. Is the litter patrol with Northport, is that still a contract?
It's still an agreement today. It is under review. We've got some legal folks from Houston working with the county attorney. There were some concerns about how that was working, and they're going through it. I don't have an update at this point as to where they are with that, but it is under review.
Okay, thank you.
It's my opinion to keep it going.
That would be great. Yeah, we would recommend that as well, but once the attorneys get involved. All right.
Okay, so at this time we will receive public testimony. Proponents of the application shall speak first, opponents of the application shall speak second, and neutral testimony shall proceed third, and any agency comments next. Do we have anybody on the sign-in sheet? We'll pause while the train's going by. Looks like we just have waste management, but I'll just double check in the, is there anyone who wishes to speak in favor of the application that didn't sign up? Anybody? Anyone who wishes to provide neutral testimony? Anyone who wishes to speak in opposition of the application? Is there anyone representing an agency that wishes to speak? See anything? Does the staff have anything you want to add, Michelle?
I don't at this time, unless there's any additional questions I can answer.
Okay. Do you have any more questions, Michelle? Okay. We're to applicant rebuttal, but I'm assuming you guys don't have anything you want to rebut. We're good there. Okay, so no applicant rebuttal from waste management. And so then, Sherry, we just add our discretion on whether we want to continue the hearing and leave the record open, or if we're ready to close it. What do you think?
I'm ready to close.
Okay. So if there are no further questions, I will now close the public hearing. It is 11:29. And then we'll move into discussion and possible motion. So what we are looking at here is if we are in agreement with the recommendation that waste management is in substantial compliance with the current, those 23 conditions, and the recommendation that we add condition number 24, which is the review.
Does waste management feel like we need condition number 24, or can we make an agreement outside of the conditional use permit to continue this discussion? I mean, you just said that you felt that it's necessary to bring this up to the 21st century.
I think we can go either way. I think.
I just don't see any point in putting condition number 24 in when we're all in agreement that it definitely needs work.
I think that's fair. I think we can go either way.
Thank you.
So based on that, are you thinking that we would strike 24 and just,
Well, it was only recommended that we include 24. It really isn't a part of the conditional use permit at this time, unless we say we want to include it in our motion, correct?
correct? Correct.
How do you feel? What is your feeling?
I mean, I'm okay with that. I think as long as everybody's clear that we expect that this happen and that it be a timely process.
Yes, well, I think everyone feels exactly the
That
same.
2020 is the year to get this done and wrapped up. So it's on the record. I mean, I feel comfortable that as long as we're all on the same page about timing and planning commission appears to be ready to do that work this year, then I think I'm comfortable with that.
Ready?
I am.
Okay, I move to adopt court order number 2019-01 and order adopting conditional use permit 2019-05 and affirming waste management is in compliance with conditions of approval as written in 2012.
I will second that. It's been moved and seconded that we adopt court order number 2019-01 and order adopting conditional use permit 2019-05 and affirming waste management is in compliance with the conditions of approval as written in 2012. Is there further discussion? No. All those in favor?
Aye.
Aye. Any opposed? Motion carries. All right, guys. Expectations. We'll get this moving.
To be continued.
All right, so we are at, it is 11:30 right now. Before we dive into regular business, could we maybe just take a pause to reset so Leslie can come back up and join us? And wondering, based on this as well, would we like to order lunch? So we can just work through lunch?
Yes.
Okay, so let's take, say, a 10-minute pause to get everything reset and maybe get lunch ordered. And then we can resume with the agenda. Come back into session. It's 11:48. We will move into the consent agenda.
It's yours.
I move we approve the consent agenda.
I second.
Okay, it's been moved and seconded that we approve the consent agenda, which consists of consider approval of November 14th executive session minutes, consider approval of December 4th regular meeting minutes, and consider extension of Hegwood water purchase agreement. Is there further discussion?
No.
All those in favor?
Aye.
Aye. Any opposed? Motion carries. All right. Under unfinished business, even though it's not really unfinished business, we're going to move up the waste management quarterly report. So come on up.
So waste management, this is quarter to date, Q4, and year to date 2019, so it runs through November of 2019. I think the last time we met, we were on pace to do about a 10% volume increase at Columbia Ridge. That has slowed down. I think we're going to be in the 5 to 6%, so we won't get our agreement in this year. But it's going to be in the 2.8 million tons. The quarter slowed down. September was a little bit slower than we had anticipated. But overall volumes are actually really good at the landfill right now. And again, I think we're going to end up being about 5 to 6% over last year at Columbia Ridge. Chemical waste management's doing really well, up 31% for the year so far, and that's going to, we got one more month in the year, so it'll be a little bit higher even still. Their volumes have gone, that's kind of an up and down line of business anyway, but the volumes have been pretty good at chemical waste this year. Safety, in the last quarter, we've had no serious accidents. We do continue to fill positions, welders, laborers, truck drivers, et cetera, operators as well. That just seems to be a continuing. We're going to have 5 or 8 positions open pretty constant or pretty regularly. Construction projects, we did do a significant phase 1 and phase 2 for gas collection, so back to conditional, I think, and CUP, but we added approximately 40 gas wells, so we increased the gas collection at the facility considerably. And then the Dalby construction, it's very near completion. We hope to be done this week, which will allow us to process drains and garbage faster during cold winter conditions. Employee and community engagement, we are looking to have a holiday party this year. It will be in January timeframe. We've got a new party planner, and she's doing a bang-up job, and we're looking forward to her. She wants to do live music and everything. So we did, and I forget timing on some of this, but Common and Goldendale have both started commuter buses in the last few months. So we've got a bus running out of Common. I think there are 8 or 9 people that are riding that bus, and then we've got one coming out of Goldendale also. We're looking at a second bus out of Common, and I think the day shift is running the bus now, and the night shift, we've got a significant group coming in for evening shift that will help out the bus also. So I expect to see a second bus coming online, coming out of Common. Hopefully it opens up more Gilliam County opportunities for people that may not want to drive, but are happy to hop in the bus and participate. Then the components, and so we have started doing the dirt glue spray on, and again, I apologize if I repeat myself, but I'm not sure the last time we talked if we had implemented that, but both of our facilities in Seattle are doing the dirt glue. It seems to be working. And then we have contracted with Watco for gondola repairs. That was a big one where they had been leaking. We've done approximately 90 so far, and we're planning to work through the whole fleet, which is roughly 250 gondolas. So we expect all of those to be done throughout 2020 and then maintain those going forward. So
Where are they doing that one?
they're doing it at Shelter.
Oh, there?
And my understanding is they got approval to do it at Shelter. I'm not sure through whom, but
I don't know if the room.
Michael Goss is going to work with someone at the county to get the thumbs up.
I have not spoken with Michael Goss, so have you? No.
We had to call him.
I have his number.
My understanding is he had talked to the county and had been given the thumbs up to do the repairs down there. Yes, ma'am.
Interesting.
I don't know. They're doing some work at Columbia Ridge right now, but my understanding is they plan to do most of it down at Shelter, and I thought they had approval to do it.
I have to touch base with them. Pursue them.
That is our quarterly, and I'm sure we'll be in touch here shortly in January, February timeframe.
And while you're up here, we were just talking about sort of wrapping up the review and next steps for sort of phase 2. And I think, since Leslie, you're still conflicted out on this, so this will be Sherry and I having this discussion. We're thinking maybe a memorandum of understanding is probably what we want to put in place.
Just for the time frame.
Just for the short that, we're 2020 is going to be the year, and also we were talking about, since our attorneys are already talking over the Norcor stuff, that I would probably just ask our attorney when he's making contacts with your attorneys on that other issue to maybe put this together, or who?
If he or she could work through me, then I can get it signed here. That's a corporate attorney that we don't really have a lot of access to. We've got a market area guy, Andrew Kennebec, who we work with, and something like the MOU would probably run through him and go a lot faster.
All right, that works for me, yeah.
So if we'll run it through me, I'll get it to the right people, and we should have it back in a week or so.
Great.
Sooner the better, so we can.
Yeah, no, I think it's time. Right?
Yeah, it really is, yeah.
If you look at the document, and I was telling Michelle, I read through it, but not having context, not thinking about, well, the Corps manages this piece, the planning commission, ODQ, and sort of how we clean it up and get it more order. I think it's very appropriate, and of course, we'll get talk to me about the part she wants to work on, so we'll definitely, I think it's time, and we're anxious to get working on it.
Great.
Be a good exercise.
I'll connect Jeremy with you when I get back to the
Awesome.
office and we'll get moving on it.
Thank you very much. If there are no other questions.
I don't have any, Leslie. Jared? No. Thanks so much. Thank you.
Thank you for waiting.
Yeah, you too. All three of you. All right. 6.1 frontier talent update. I don't have a whole lot, but did want to just note for the record the big news that our long saga with USAC is over. All of the funds are in. Yay! So, and I was thinking back to where the court was a year ago during this meeting, and basically being told that Frontier Telenet was on the verge of bankruptcy, and that emergency action needed to be taken to stabilize it. And so it's nice now, almost exactly a year later, to be able to report that all the funds have come in, it's stable, we're moving forward in a more methodical, thoughtful way of managing it. So, wanted to report that as good news for the holidays to everyone back at home that's watching it. That this is one of those areas that sometimes not having action is actually the good news, which is we don't have any emergencies or fires that we're trying to put out. And so anyway, I just wanted to share that, that bit of information. 6.2, the Fiber Council update. Catherine Greiner and I have been meeting with several potential customers for the dark fiber that we have, and several who have expressed an interest in moving forward with negotiations on prices and things like that. So our telecom attorney, Christy Munson, is drafting an agreement for us to take a look at. So the city's attorney took the first stab. She's looking at it to make sure that county's interests are protected. And then once we have that draft in place, we'll be sending that out to those potential customers and kind of getting their read on if this is workable and what pricing structure is going to work. So that is the update that we're looking forward. So I'm hoping in the first quarter of next year that we may have some customers that are ready to move forward with signing an agreement and starting to actually see some income come in off of that lottery. So that is that update. We will go into 6.3, which is second reading and adoption of ordinance number 2019-03, an ordinance to adopt proposed text amendments to Gilliam County zoning and land development ordinance. So this is the second phase. Last time we met, we did the hearing and first reading for this. It's related to the Woolworths project in particular. And we proceeded with the first reading, and so it has been 13 days since. We are able, if we would like to today, to proceed with the second reading and adoption if there's interest in doing so.
I believe so. I move to have the second reading of ordinance number 2019-03 by title only.
Second.
It's been moved and seconded that we have the second reading of ordinance number 2019-03 by title only. Is there further discussion? All those in favor?
Aye.
Aye. Any opposed? The motion carries. So ordinance number 2019-03, Gilliam County, Oregon, an ordinance to adopt legislative amendments contained in Planning Department file number L-2019-02 to amend the Gilliam County zoning and land development ordinance related to the limited industrial zone definitions and conditional uses allowed.
I move to accept the second reading by title only and adopt ordinance number 2019-03.
And I second.
It's been moved and seconded that we accept the second reading by title only and adopt ordinance number 2019-03. Is there further discussion? All those in favor?
Aye.
Aye. Any opposed?
No.
Motion carries. Okay. Moving on to 6.4, second reading and adoption of ordinance number 2019-04, an ordinance designating the office of Gilliam County Commissioner as nonpartisan, referred for the May 2020 primary election. So this is another one. We did the first step, the first reading during our last regular meeting. We've had 13 days pass, so if we're interested in moving forward, we need a second reading and adoption. I did talk to our county council because of some comments or questions that were raised by Les Rourke about public input and what that would look like if the voters were to approve this in May. And basically what they said is that yes, the county court can by resolution determine what that process looks like, so long as the ultimate decider is the county court, because that is required by Oregon statute, that we actually make the appointment. But that process by which we receive candidates, we can determine that. And so should the voters approve this in May, then the next step would be going back to county council and drafting a resolution that basically puts in place whatever public input we think is appropriate. So if we wanted to do, for instance, if we wanted a public committee that helps decide who those nominees are to forward to us, in the same way the precinct committee people do right now, they suggested that you put that in place, and then just as part of our regular appointment of committee members in January of every year, that we appoint those people and just have them in place should there ever be a retirement or a death of the commissioners. So those are in place, and that way the court is not scrambling to find people to serve in those roles. That's just a regular part of doing business, and we have people who solicit their interest in serving on that committee should there ever be a need for it to do its work. So I just wanted to put that on the record because I know that was a concern Les had raised, and it appears that we have tools to be able to provide for public input should this be something that the voters move forward with approving in May.
And I also wanted to kind of give some background of what my feeling is about having these positions as nonpartisan, and the reasoning behind, a lot of the reasoning behind my thinking. One of them is, and I don't know if anybody has read the East Oregonian from, I think it was yesterday's, the front page article about the rise of the unaffiliated voter and the percentage of unaffiliated voters that we have in our counties. And Gilliam County, actually, the percentage is 31.6% of our registered voters are unaffiliated. And they attributed some of that to the fact that when you renew your driver's license, if you aren't registered to vote, they just automatically register and you're unaffiliated unless you do something to change it. But even that being said, I know there's a lot of people that have registered as unaffiliated previous to that, happening. And their voices aren't being heard in the primaries. And if we can change that within the county, I'd love to see that. When we go to AOC conference, Association of County Conference, or any of those, I don't know if they're Republicans or Democrats or independents. We're just all working together. And I wish the rest of the world worked that way. So that's what is my reasoning behind this, and I want people to know why I think it's a good idea.
Yeah, I agree, because the way it's structured right now with the partisan, if you have, say for just reference sake, Leslie's race, because Leslie's the next seat that's up, you have 2 Democrats that run and no Republicans. Well, what that means is that only the Democratic voters get to select the commissioner, because there's no way, whoever wins that Democratic primary becomes the commissioner by default, because there's nobody else on the ballot from the Republican side. But in a nonpartisan race, all of the voters get to make that decision at the primary level, or when, on the primary ballot. And so I think, we definitely have heard the clerk's office frequently gets people that call on the commissioner races. They're watching them and are upset if they're unaffiliated or independent and they don't have an opportunity to weigh in on those candidates. So this is a way to allow, I think, a greater voice in who represents the community at the local level. So that's my view on it.
Yes, and one thing I would mention too is, and we talked about it the last meeting as well, but 26 out of 36 counties in Oregon already have moved in this direction. The other thing I liked is the one little part of the ordinance that was prepared by the attorneys, and it says, that the county court finds that the electors of Gilliam County should have the opportunity to decide whether the office of county commissioner should be nonpartisan. So it's, it's time to let the people decide, do you want to continue the way it is, or do you want to move on to nonpartisan, which I like that. The other thing too is that these are the only two positions, I believe, in the county courthouse that are. So the judge, the clerk, the assessor, the surveyor, the treasurer, district attorney, and sheriff are all nonpartisan. So that was the thing I liked that.
That's an excellent point.
So it sounds then like there may be an appetite to move forward with the second reading and adoption.
I think it's my turn.
Yeah.
I move to have the second reading of ordinance number 2019-04 by title only.
Second.
It's been moved and seconded that we have the second reading of ordinance number 2019-04 by title only. Is there further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion carries. Okay, in the county court for Gilliam County, Oregon, ordinance number 2019-04, an ordinance designating the office of Gilliam County Commissioner as nonpartisan, referred for the May 2020 primary election.
I move to accept the second reading by title only and to adopt ordinance number 2019-04.
Second.
It's been moved and seconded that we accept the second reading by title only and adopt ordinance number 2019-04. Further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion carries. Okay, so next steps for this one is I will get this ordinance signed, and then it goes to the DA's office. And the DA is actually the one that will take the first step at drafting the ballot title. And that will then need to be submitted to Ellen and then noticed in the paper, and there's a period of time that members of the public could object to that ballot title. So we'll get this moving. The ordinance, basically, as you guys know, authorized county staff to take the steps we need to get it on the ballot, and so we will be doing that and following those processes.
Right.
Okay, moving right on to 6.5, consider approval of resolution number R 2019-07, a resolution authorizing the sale of Gilliam County real property. So this is the Arlington Saddle Club request for that quarter acre that we've got. Did our attorneys?
They've indicated that the statute does not require notification to adjacent landowners, and they also indicated they don't believe there's a mechanism by which any neighbouring properties could object. They haven't confirmed, but that is their take at the moment. We're still waiting for final confirmation of that.
Okay, so here's what's happened. We have the statute allows us to do a direct private sale if the property in question meets certain conditions. Those conditions are basically the value of the land has to be less than $15,000, which this one does. The assessor has it currently appraised at $980, I think. And then the property also needs to be unsuitable for a dwelling. And so they reviewed, Michelle sent over some of the zoning information that we know about the property, and based on where it is and how it's zoned and access to it, they concluded that it was unsuitable for a dwelling. And so based on that, it would meet the ORS requirements for us to do a direct private sale. The requirements on our end is that we have to notice in the paper our intent to do that private sale. We have done so. It was noticed 2 weeks ago now, and then again, it'll be noticed again this week. And then 15 days after that notice, we're allowed to move through with the sale. So all of those steps have been taken. We had one of the other adjacent landowners come into the office this week, upset that we were not opening it up to all of the adjacent landowners potentially to purchase it. And so I went back to council to, one, just double check that we did not need to notify the adjacent landowners, and that is what Lisa was just sharing, that they have told us that that was not a requirement. And so my second question to them was, if an adjacent landowner objected to the sale, one, is there a mechanism for them to object, and if so, what process, if any, does that trigger internally for the county court in our ability to complete the sale? They, as you just heard, are figuring that second part out. So the question before the court is, do we want to wait for that determination? I mean, we don't, the adjacent landowner is not here to object to it. So presumably,
I'd like to wait and get whatever the council is going to tell us. And I based that on, I actually was in Mrs. Atkins' office and spoke to the adjacent landowners as well. And it was brought to our attention that the reason he knew about it was because a representative of the Arlington Saddle Club had brought it to his attention. And so I don't know what their thinking was, and if they were concerned that he would come back later to, to be concerned about it. So yeah, I think we need to wait and find out for sure what our process is if he does object to the sale, and if he's interested in buying, and what that looks like from there.
I agree. I didn't know that anybody had raised an issue, but yeah, I don't think this is a big hurry, and I don't know that this is any big hurry to push this through, so we might as well hold on.
yeah, and I talked to the Saddle Club and just let them know that obviously, even if we went through with this, there still needs to be drafted and things like that. And so they had indicated, I think Rucker's out of town until February timeframe. So there's not a huge, I mean, Jim would be the signatory, I think. And so I had talked to him about, if this goes through, to circle back with me once they're back in Oregon. So I think doing our due diligence is always a smart idea when we're dealing with county property. So for now, why don't we table this until January 8th and then see if we have an answer by then. And I can also just circle back with the Saddle Club and let them know that this issue has arisen, and that may impact the process that we need to look at for a sale. Okay.
Can I ask a question?
Sure.
It's kind of a little bit not related to the sale exactly, but the resolution number R 2019-07, is the R new? Putting an R in front of
The R is new, and I think we're going to start doing that. Where it's become confusing is that we've got ordinance that are coming and resolutions that are coming at the same time. And so the numbering of them, the R I'm thinking is a shorthand that will just, when we see it, that way we know which book it's in and where it's located. So just an easier kind of way to track those.
If it doesn't have a letter, then it's an ordinance. If it has an R,
then it's a resolution.
Sounds good. Like,
I thought it was good.
Just an efficiency within the courthouse to be able to track down these documents on short notice, which we occasionally have to do around here, right? So, anything else on that? We'll just go back and get 8 and see where we are. Okay. On 6.6, consider approval of PERS employer incentive fund payment. So, as you guys recall, several meetings ago now, Nathan had come before us and asked for permission to apply for the PERS Employer Incentive Fund, which would allow us to make a lump sum payment and then leverage state matching funds to help pay down our PERS liability. The application was submitted. We're currently number 17 on the waiting list. And so we're thinking it's probably, could somebody go open the door? Lunch is here. Thank you. My mom just texted. So,
What's other people want to do?
We're having a public meeting.
Why is the doors locked?
Well, that brings up the point I have too. When we close the door, anytime I think we close the door when we're having a meeting, I think we should just slip a sign on the door that says, please come in.
Right, I think it's because it's lunchtime, the 12 to 1 hour, they may not come.
No, it was
No,
not.
it wouldn't open for me either.
No,
I had to knock on the door to
I
get
did
somebody to
too.
come.
I did too.
It was propped.
And then, well, we propped it when I knocked and she let me in. so
She
I
said
don't know.
something about they need to replace the doorknobs or something. but,
Really? Well, then she should be out there to open the door.
Yeah.
We need to do something.
Yeah, you do need to put a sign when we're trying to close off the noise.
Yeah,
So that people don't think we're in close them, right?
Probably contends for access.
No judge.
You're kind of busy.
Okay, so circling back, we're number 17 on the waiting list. I talked to Nathan and Ellen. I think it's probably pretty unlikely. Hi, Mom.
Thank you, Mom.
Thanks, Mom. You want to just set it on the table, please? It's unlikely. We're thinking that we'll probably actually get approved for the match funding. However, at least this go around. However, the way PERS has structured it is when they notify you, you have like 5 days to cut a check. And so what I would like us to do is just on the off chance that we do make it up into that funding pool, that we go ahead and make the motion that would authorize Ellen to cut that check if we're notified. So, yeah. So basically, we are eligible for up to, where we would be able to put in 1.2 million, and then the state would match 25% of that.
Right.
And I double checked, if we would like to go forward, there are funds in the SIP discretionary line item.
Okay.
Questions about that?
No, sounds like a plan.
Needs to be done. I move to approve a lump sum payment of up to 1.2 million for the PERS Employer Incentive Fund. Funds to be taken from the SIP discretionary line item 235-100-5-50-5120.
I'll second.
It's been moved and seconded that we approve a lump sum payment of up to 1.2 million for the PERS Employer Incentive Fund. Funds to be taken from the SIP discretionary line item, which is 235-100-550-5120. Is there further discussion? All those in favor?
Aye.
Aye. Any opposed? No, motion carries. Okay, how are you guys feeling?
Sorry.
Okay, so.
You're asking Leslie, she wants her food.
Okay, so shall we take, so we don't have to eat on camera?
Oh.
Just a few minutes to eat?
Okay.
And come back?
Okay. Yes.
You want to do that?
Yes.
Okay. Let's do that. Let's take like maybe 20 minutes.
Okay.
Is that enough?
Fine.
Okay, we'll take like 20 minutes or when we're done and come back and do these last couple of items. We are back in session. It is 12:39. Let's jump into new business. 7.1, discuss driving loan modification. Okay, so as by way of background, we currently have a business development loan with Vicki Ackerman for the drive-in in Condon. The original loan was approved back in 2016. It was $158,500. It's a 10-year loan with sort of a tiered interest rate that you can see in the attached documents. I asked Nathan for an update on how she's doing with payments. She's making regular payments. What we noticed is probably seem pretty obvious during the winter months, those occasionally she misses one in the winter months, but generally makes up for it in the summer, and we'll do a second payment basically to kind of make up for what she missed, and what you sort of expect with a restaurant that's so closely tied to the tourism coming through in the summer. So Ms. Ackerman contacted the county court about the loan earlier this month, and basically she's got quite a number of maintenance needs that she's trying to meet, heating needs and other things that are just impacting her cash flow right now, and then coupling that with the fact that we're going into the winter months. And she's feeling, I think, concerned about her ability to keep up with the payments. And so originally she had approached us about taking out more money to cover the cash flow. But as our loan program is dormant right now, Nathan and I sort of were brainstorming ways that we could maybe be of assistance without reopening the loan program, without having other guidelines and things that we had talked about wanting to put in place. So what we came up with, which is really what Nathan came up with in a spitballing sort of session, was the idea of just giving her a short reprieve from payments during this winter season, perhaps like 6 months, and just extending the term of the loan, which is more in alignment. I mean, we obviously did that with the TV co-op, extending when those payments came in. We just did a modification with the Liberty Theater. So I think those are, we've been willing to work with borrowers previously. So I don't think that's necessarily out of alignment with what we've previously done. So what I'm looking for is just some thoughts from you guys on, is this something that we would be open to doing? Obviously, the county council would need to redraft, do an amendment to the loan documents, and so there'd be other steps that would have to come back to the board. But before I got them working on something, I wanted to see what the appetite was for talking about modifying the terms. Thoughts?
So this is just, well, the thing that I started thinking about was the personnel, or the public records request policy briefly, but I'll bring it up when we talk about that. So this is just like supposedly, I mean, it's supposed to be a one-time thing.
Yeah, so the idea
Not
is, yeah, I mean, obviously we don't want to own the drive-in.
No.
And in most, I think Nathan felt pretty confident that she is making regular payments. It's not one of those situations where the payments have stopped coming in. I think she's proactively coming to us anticipating she's going to have a cash flow issue and trying to proactively resolve that. So I commend her for that, because we have other entities, as you guys know, who have just stopped paying and haven't really communicated with us about why they're not paying, or tried to work it out with us to figure out a better way. So yeah, I mean, I think what we would be looking at potentially is doing a short reprieve and then just adding those additional months on at the back end, rather than beefing up the payments, because that will probably put her in the same position she was in before.
Well, and if these improvements caused her to need to close for any reason, that doesn't help the city either, because then she has no cash flow coming in, so.
Exactly, and Nathan and I were just surmising that it's likely that when she bought it, which I can attest, because having a house that burned down, and my parents had to buy all new the same time, things started going haywire all in the same year, and so I suspect she's experiencing something similar, where the previous owners probably made upgrades, and those appliances and upgrades are reaching end of life all at the same time. And so with any luck, the improvements that she's making, those are one-time improvements that then would carry her through the rest of the loan. Thoughts on, or other questions? What do you think, Leslie?
Yeah, I'm okay with that. Yeah, I think we need to.
Okay. So what I will do is I will talk to council about drafting up an amendment. I've already obviously talked through this with Vicki, and she was very appreciative that we would even consider it. So we'll get this rolling. Since we're really talking about kind of postponing payments, are we thinking 6 months? I picked that.
She asked What did she ask for?
She did not originally she didn't ask for the extension, she'd asked for more money, and so I sort of threw this out, and I picked 6 months only because that gets her to June, which is when her traffic should really kick up. And so I thought, you know, I didn't want it to be so short that it actually doesn't achieve what we're after. I thought maybe if we extended it into the summer months, then that would have cash flow that would be sufficient to start payments again.
Well, and she probably doesn't know for sure exactly what some of these costs are gonna be either, does she? It's like,
Yeah, because some of it's like a major heating.
now the HVAC thing is probably.
Those can be really expensive. So, but yeah, okay, so I will have council draft some documents. I am not anticipating they'll be able to turn them around by the 8th. So I'm wondering if we would consider basically me just letting Vicki know that that payment in January is not due while because it's on our end, it's getting the paperwork sort of straightened out. So kind of treat it as if it's being, you know, she's receiving a reprieve for the next 6 months, basically.
We're just waiting for the paperwork.
And then we'll get the paperwork in place in January.
It's been approved, we just want to get the paperwork.
Exactly. Okay.
Speaking of the loan program.
Yes.
When are we planning on looking at that again?
Good question. I'm thinking we probably want to, after we get through the grant approvals in January, we probably want to bring that back up. One of the things we've been cooking around internally is, as you know, our treasurer really does not want to be a banker. He wants to be a treasurer.
I've heard that quote.
Yes, you may have heard it a time or two that we are not a bank, so he would want me to repeat that here. One of the things we've been kicking around as a potential solution is going out for an RFP and providing a lump sum to the winning entity of the RFP to manage the loan program, and have that be. So we are the starting funding for that, but whichever entity takes it over then would be providing those loans.
I believe we talked about that before, like didn't Gobi help with us?
GEODC.
GEODC, thank you. I know it was one of those ones that started with a G. But I think the problem, if I remember, was that we didn't have that local, we might be more apt to approve business that they would look at and say, no, that's not a very viable
Maybe that's been
investment. But we did kind of like, and I don't remember, was it this court? Was it the last one? I don't remember, but having a little more of that local control.
That's not just, I think you could structure the RFP so that a local entity was making those loans. There are some people that currently make loans. That may have an expertise in that may have an interest in it long term. Because we had talked about, and Nathan and I have been talking about maybe even moving the current loans off the county's books. And just really moving that over into an entity that still has a local, and maybe part of the RFP is setting those parameters on what our expectations are for how, if we were to put out an RFP, what we're looking for in those proposals that come back. It's just an idea that we've been kicking around.
I'm interested to hear more about it.
Yeah. I'm just, having gone through the Liberty Theater, Teresa can attest to this, for a $10,000 loan, it took a lot of staff time to get those documents. I mean, we're talking between all of us, probably several hundred, if not more than $1,000 worth of staff time and council time getting those documents filed and prepared. And so at some point you have to ask whether that's worthwhile for the county. I mean, I think we all are in agreement that there's a need for those kinds of loans. I think we need to have a discussion about whether we're the best entity to manage those long term. So, anyway. Be thinking further discussion. Okay. But takeaway is that Nathan and I are cooking up a couple of options that we can start kicking around as a point of discussion.
Sounds good.
Okay. All right. Let's move on to 7.2, consider approval of resolution number R 2019-08, a resolution adopting a public records request policy and procedures. All right, so this is, basically this is establishing a policy that brings us into compliance with the current Oregon public records laws that were recently updated about timeframes and things that we have to respond to public information requests. It also has some stuff in there to just make sure that we're being efficient in how we respond to these requests, that our records are preserved, and then it establishes a fee schedule. Our legal counsel drafted it, and so it's definitely in compliance based on their view of it. We did share it with the other elected officials just to make sure that everything was kosher, and there were a couple of items that that Gary had concerns about that have been resolved in this draft. So Lisa worked with him, and I think he's good now. And the other thing just to note is that I think next year we should plan on seeing a lot more resolutions on the agenda. So council has sort of advised that we need to use that more as our vehicle to enact our will, as it would, and so you'll see a lot more of those, and so that's why there's a resolution. The resolution is enacting the policy that's underneath it, basically.
Okay.
Questions about?
I had several questions, but I called them visit with Lisa. And thank you. A lot of them answered for me. But of course, last night I thought of a few more.
Of course you did.
Yeah. So where is the form that we're going to use?
So once we discussed and approved and agreed to adopt this, I will create the form, but the content of what's going to be in the form is in the verbiage of this policy.
Okay.
So keeping it very simple as well, so that it doesn't deter people from submitting a request.
Well, and as I read this, I tried to stay in the mindset of someone from the public, because I've been on the staff end of it, and so I know what that's like. But I was trying to think about it as a member of the public, and hoping that we weren't going to make it unduly cumbersome for a member of the public to get information when they want information. And so there was just a couple questions. And when we talked a little bit about the date of things, asking this person to provide a date. But if it's something simple, like I would like a copy of the economic enhancement ordinance, we're not going to
Right, because they would have no clue when
not going to require
ordinance took place perhaps. So I think it will be an optional date if they're asking from the specific, backdated into some history, if they can give an indication, if they have knowledge of when that might have taken place. It will mean those of us who are sort of delving into the files with perhaps not so much history can get there quicker for them.
Okay, that sounds good. The other thing I was a little bit concerned about is using a form. So if somebody just wanted something simple like an economic enhancement ordinance, we're not going to allow someone just to email us and say, can I get a copy of that? We will have to fill out a form.
So what's happening at the moment is when we get a flurry, which we do from time to time, of these requests, they're coming in all different shapes and sizes, and so it's taking staff some time just to assess what's actually wanted, because it may be coming in email, or maybe the person walks in the office, or you get a post-it note, or an official letter, or a phone call. We're just trying to make it uniform so staff can process those requests much more quickly without having to sort of efficiency. We've got the fullness of the information, but usually we can turn it around super quickly without them actually incurring any cost, especially if they just want an email response. Whereas if we take longer to do it, then we start to get into the staff labour charges. We're trying to avoid that.
And then there's a paper trail too, if that's ever needed, but who's requested this information?
Yes, and it allows us to monitor how many requests do we get here, what kind of impact does this have on staff time, so that we can ensure, we're appropriately staffed to respond to these.
And I definitely see that. I see the upside of that. I just feel, I'm just afraid that someone will think that, you're making me fill out a form, you're just trying to prevent me from you know, getting the
I don't think you
information.
could probably go anywhere else
And it doesn't.
for something without being required to make a formal request.
I see that, I see that. And like I said, I was just trying to read it from the public
Yeah, like I
viewpoint.
mentioned, it's not to make it extensive. If staff needed to do follow-up to get more details to provide the information, that's subsequent, conversation with them perhaps to drill down into the specifics. But we need something uniform as a starting point that can usually be turned around pretty quickly. It just depends on
I
the
would think
extent of the
Watsco County and Hood River County and Umatilla County, Montana, they probably have a form.
And then the last question I had is, especially when we were talking about an attorney charge, charging them if an attorney is involved about, it as part of this request, that we would possibly pass on those attorney charges to them, and I was just a little bit concerned about that. And then when we started talking about the, that loan, the thing we were just talking about, that loan modification, I couldn't think of the word, where we don't pass on those charges. When we have to do, when something comes up like that, we're not sharing that attorney cost with, but yeah, we're thinking about doing it on the public records request. It's just made me go,
And to be clear, I think our policy says, so the attorney telling us whether we have to comply or not, that's on us. So if somebody comes to us and is requesting a document, if I send it to Jeremy and say, hey, do I need to release this or not, that initial question to him is on the county's dime. Where it comes into play is if we have sensitive documents that need to be redacted and need to be in compliance with state law for what we can release and not release. I mean, right now, we're pretty fortunate in that those requests are few and far between and they're pretty minimal. But what you could run into a situation if somebody was in a lawsuit with us potentially or something, and there were a number of issues that needed to be looked at from our attorneys, we probably want to have some provision in there that allows us to recoup some of those costs.
some of the safeguard grounds.
Yeah.
Okay.
The other piece that's in the policy as well is that we will always call back the requester to let them know of any potential costs they're going to incur, whether it's, a 25-cent photocopy or 250-hour time with an attorney or whatever. So they will have a heads up and an option to say, no, I'd like to back out of that request, I do not want to incur the costs. So we wouldn't go ahead without their say-so acknowledgement of that.
And we do always have the ability within the policy to waive fees if we think that that's in the public interest to do so. So, if we decide that, actually the information you're requesting is not only important for youth, but for other people, and so we're going to release it widely, and we're not going to charge you for that. We always have the discretion to say, so I'm not anticipating if someone walks into Nathan's office and requests a copy of the budget and they already have a printed staff that are sitting on his counter, that he's going to be necessarily deciding he may just decide, I'm going to waive that. It's already printed, it's sitting here kind of thing. You can walk out with it kind of thing, so.
Okay, thank you.
Other questions on? It's going to be nice to have this. I was looking back and I think the last time that they approved it was 2008. So we have not had a policy, an updated policy in place for a long time.
That was consistent with the Oregon laws?
Yeah, and they did some significant revamping of the Oregon. There's a lot more tighter deadlines for us and expectations for us as the public body to.
We need to move and go home. All right. We didn't move around enough.
So, are we good?
Yes.
I'm good. Is there a motion?
I move to approve resolution R 2019-08 and to adopt a public records request policy as presented.
Second.
Okay, it's been moved and seconded that we approve resolution number 2019-08 and to adopt the public records request policy as presented. Is there further discussion? All those in favor? Aye. Sherry was an aye. Aye. Any opposed? The motion carries. Just in case it wasn't on the tape. Okay, we tabled 7.3, so we will go into 7.4, which is discuss Pioneer Community Development Corporation Housing Memorandum of Agreement. That is a mouthful. So I will give you kind of the overview, and if we have questions from us in the audience. So basically, as you all know, we have, in February 2018, Gilliam County entered into a memorandum of agreement with PCDC, which basically provided a significant amount of county investment for a number of grant and loan programs that PCDC is administering related to housing accessibility and affordability and upgrades and development. The MOA was amended later that year, so last year, to add 2 additional grant programs. During the negotiations of the MOA with the previous court, the Housing Solutions team had recommended that PCDC be able to utilize up to 10% of the county funds for administration of the program. But what we've recently discovered is that that provision was never included in the memorandum of agreement. And so Teresa and I went through the old minutes and I looked at some of the old videos, because thankfully some of those discussions happen after we've been on YouTube. And I haven't been able to find with anything that indicates whether that was purposely omitted or whether that was accidentally omitted. So I don't have any intent. I don't have any clue about what the previous court's intent was, you know, on whether they discussed it and decided to not do it or whether they just forgot about it. With all that being said, Rob contacted us earlier this month expressing some concern that it obviously hadn't been included. They had been under the impression that it was included, and so some of those funds have been expended on administrative purposes. And so what we're looking for today is just some clarification on the court's comfort level with allowing those funds, some of those funds, to be used for administrative purposes for PCDC. And if that is something that we want to allow, then we would need to draft another amendment to the agreement, just clarifying that that's an allowable use of the funds. That's my summary. What do you guys think?
Can I interject anything during this? Or?
Yes, sure, go ahead.
And I think you hit the nail on the head in your previous discussion of how many hours it takes to do a $10,000 loan for your staff. And if you look at where we came from, which was, what, 10 hours a week, with 3 or 4 programs that are getting used, and now we've got in excess of 6 programs that are being used. I need that additional dollars to administer this program. And I'd like to take this opportunity to kind of talk about what we have done, so you can see, you know, where these dollars are being spent as far as admin goes. And quite frankly, shocked that it did not show up in any minutes, because I remember specifically, especially Commissioner Weimer and Judge Schaefer. I don't remember whether Leslie made a comment about it at all, but I know that Judge Weimer or Commissioner Weimer was like, well, of course you're going to need dollars for it. And it was part of our memorandum that we had given from the Oregon Solutions, was part of it in there. And I'll take as much of the blame as not seeing it in the MOU as anybody. But I was also the one that brought it to your attention. So I wanted to know that to this point, we've only spent $15,000, and 10% of the 1.25 would equal 17.8 over the 7-year period of the program. So we really have not used it to a big extent to this point, which I try not to, because I want to give back as much money as we can to the county. So that being said, to this point, we've done a rehab grant in Condon for a house, vacant house that will be a rental. We've demoed 3 separate derelict properties that are now all on the market for sale that have utilities already to them, which was part of the program. We have done another rehab grant for a house that was not previously a rental. It was a single family. And those folks not only took advantage of the rehab grant, but they also signed a 5-year agreement saying that they would keep it as a rental for 5 years. We did an adult house here in Arlington, which recently sold. We've been paid, that was a $150,000 construction loan that we did, and we received all those funds back after the sale of that. We have another one here in Arlington that is underway on Hemlock up here. We've got an application in right now for a duplex in Condon. They've purchased a lot there already. We have three properties that were not previously rentals that we currently have applications for that will become rentals, but that were vacant in Condon, like I said. And what we've seen with the ones that we did bring to market, they go just like that. So we are getting some things accomplished here. It took a while for people to kind of get going with the program, but once kind of we've been able to do that, people hear about it and they say, well, let's go do this or that. We are going to look at, even the old people realize that we have to have a website. So we're looking at having a website built for us. Hopefully they won't require too much work on my part, so I wouldn't want to screw it up. We also have removed 2 trailers from the trailer park down here, and the owner has actually been working with a couple of mobile home factories to get pricing on some models, and got some really good prices, and he's going to offer those out to the public for sale, so we can start getting some new stuff in there. And the ones that we took out were, basically unlivable. I mean, and there's certainly more that we could take out, and we have another $20,000 that was previously granted to us just for that purpose to do that. So we're hoping to get some more of that done as well. And like I said, I've got 6 applications in right now for both rehab and new construction.
Cool.
So it was a long time getting going, but now we are. And I also just want to point out that the MOA, the 10%, is needed to manage a program like this. I mean, you think a $10,000 loan modification is a big deal. You do a construction loan, where it's.
Is that enough?
Is
10% enough?
I think it will be. We'll see. The other thing that I've done is because that money that we receive from the county, a lot of times is sitting in our accounts. So I've gone, and of course the bank won't give you anything these days. So we've gone out and started a program of buying T-bills that are, at least 1.5%, 2%, and there's no risk to them because of their government treasury. So we've been able to create over 20,000 so far in interest.
Wow.
Just on those, and we're using that for operations.
That's great.
So that helps, both of us actually.
Yeah.
So we're doing some things like that, and plus when we do a construction loan, we're receiving interest from that. The construction loan that we did, we received over $6,000 in interest over the time it took them to sell the property. So, and PCDC previously was always been hamstrung because all of our loans were no interest, no payment, type for lower income folks that made sense. So there was really no income, coming back to us. It was just principal coming back when the loan gets paid off. So, but that's where we are, and I think that this next year is going to be really, really great. I mean,
That's really exciting.
there's 3 or 4 other things that we've got going that they haven't applied yet, so in my mind, it's not there. So, but just know that the interest has really begun to pick up.
That's great.
It is. It's exciting.
Fantastic. So
how do we fix this?
So what I need from you guys is some direction on your comfort level on whether you feel comfortable for those funds being used for some administrative purposes. If so, I need you to let me know what that percentage is. And then our council, I will work with Rob and our council to get an amendment drafted that will come back to the court that we would approve.
You know, one thing I would point out as well, in that when you're considering that percentage, is that, you know, grant dollars that we put out are gone. You know, so that 10% is 10% of what we actually have, you know, to work with.
Yeah.
So if those, you know, we've already got.
So how much is that? How much?
Right now, we've got.
And how much?
Grant funds, right now, we've sent out $44,700 in grant funds. And I've got, like I said, 6 applications that are, 5 of them for grants and 1's for a loan. So you're looking at another probably 25,000 there. So that would be 70 almost removed from the pie. But we're also 2 years in, so I'm not saying that, you know, I'm just saying that's something that you need to consider when you look at that percentage, because the total amount is going down.
Yeah.
You know.
So have you looked at the calculations, you into that 10%?
Like I said, right now, it would be about $16,000 a year that we would have access to of what we currently have. And like I said, we've only used $7,500 the first 2 years each, based on what we've drawn from the account.
Thoughts, ladies?
So 10% doesn't sound like enough to me, does it?
Well, like I said, we haven't used anywhere near what the 10% of the other was, but.
So is the 10% we're going off of the original loan amount?
Correct.
Or the original grant amount?
Correct. But what I'm saying is I don't think that we thought about the fact that as the grant dollars go out, you know, that amount comes out.
There's less funds in there than, right, yeah.
I mean, ideally, you know, from an administrative standpoint, I would like to stick with the 10% of the original, because that's what we determined through our Urban Solutions program that it was going to take. Was, you know, approximately $125,000 over that 7-year period. So I would prefer to leave it as 10% of the original amount.
Yeah. You guys are on board with that?
Yes.
Okay. So we will get council going on drafting an amendment. It shouldn't be too much. I mean, I'm thinking a single page would probably take care of this. I'll probably send it to Christy, since we're giving Jeremy some other projects with the waste management stuff. So we'll get it over to Christy's shop and see how quickly they can turn that around for us. And depending on what she says, we'll either try to get it back on the agenda on the 8th, but realistically, with the holidays, I think we're probably looking at the 2nd meeting in January for it to come back to us. But yeah.
You know, just from a timeline standpoint for the court, based on our current, you know, administrative funds in the bank, we're good for quite a while. So don't feel like that you need to do this immediately because I need the money. We're okay right now, but, you know, once this was brought to my attention by our accountant, and I was pretty embarrassed. But once that came up, then obviously I had to let you know. But we're in good shape right now for, I don't know, probably several months. We've got some big bills coming in, but we're okay right now.
Okay.
So don't feel like you know we have to have this done by next week or anything.
Work over Christmas?
I will not be working for Christmas.
But we're action oriented though, so we'll get it done as quickly as feasible.
Yeah. You don't want to get swept up in our budget cycle. So we're trying to get things off the plate before the budget cycle.
Okay, go.
Sweeps in. Cool. All right. So I've got my direction there, and I'll bring it back when it's ready. How about that? Okay.
Thank you very much.
Yeah.
Thank you, Rob.
Okay.
Great job.
Yes.
Exciting lunch.
What's that? Free lunch?
Free lunch at 10%.
Thanks a lot.
Thanks.
See you later.
All right, let's, court member reports. Leslie. okay if we want to keep them short.
Okay. You say that right before I start. I just had the one meeting, the North Central Public Health District meeting on the 10th. Public health is facing some challenges. Besides the, I mentioned at the last meeting that they may ask for increased funding next year. One issue is, their salaries are below norm.
The nursing salaries, right? Or all of them? All of them, okay.
Across the board.
I know the nursing ones were short, but I
Yes,
didn't.
and that's the one they're having the most problem with now because they're trying to hire a nurse. The other thing they are hoping to do is that PERS side fund. They have the opportunity to do what we did as well, but they don't have the funds. So the way it was explained though is like you either pay now or you pay later.
Right.
So that's another issue. And then the third issue is, and I don't know where we would stand on this, is building updates to that building in Wasco County. But it's, the Center for Living has moved out of the upper floor and they would like to move it into that space because it's some good big space, but boy, it needs some, we had a tour at the last meeting and it needs a little bit of help with like painting and flooring and just some basic things like that. So those are a couple of issues. And then on top of that, Terry has decided to retire.
Oh, really?
So as of June 30th, she's retiring.
So is she, as her last hurrah, every Wednesday, she'll do like a little road tour and come see all of our budget committees for the increased ask?
She will do whatever we need her to do.
Because I'm kind of thinking if, depending on what the size of the increase, I think it might be helpful for her to come talk to the budget committee.
For sure. And she's asked me before, do they need to come? And I said, I'm kind of like, oh, no, we're good. But, she would be happy to come talk to us about anything, anytime we want her to, I'm sure she would come. But she also told me after the meeting, when I spoke with her a little bit, she said, she does feel like she's leaving them in pretty good shape. Because, right now we're working on strategic planning. She has tackled some big projects that need to take place. So she's
very confident, in that role.
She feels like she's leaving us in a pretty good, but it's kind of frightening to see her go.
So what's your plan for replacement?
She said, we're going to talk about it at the next meeting. Because it was just announced at the last meeting, and we all kind of went, exactly. Yes. So that'll be coming up at the next meeting. She also mentioned that she was started working with Chris Fitzsimmons to put together a emergency preparedness tabletop exercise. So that's something that we should be hearing more about because it will occur in Gilliam County. She also gave me some talking points. I will give you each a copy. She said this isn't really like a brochure or anything, but if people ever ask you why are we giving money to public health? What do they really do for us type of thing? She gave me those if you each wanted a copy. Thank you. And it's a good little list that shows, this is what public health is all about. If somebody were to ask you, like I was asked at the last meeting. And then that was the only meeting I had, but I did get to attend some fun events. Since I just had the one meeting, I just wanted to bring up that I was able to attend the Festival of Trees in Condon, and that was a wonderful event. I think it was their first annual, so hopefully we'll be able to continue it. And I don't know how much they raised, but I think they had to have raised a good amount. Church Bazaar. I think the Christmas program is this evening, isn't it? And then I got an email that said there's going to be a Merkley Town Hall on January 5th.
That one will be in Condon.
At 5 p.m.
I will be there and seeing and go part of that.
Good for you.
And then I just have one question. How was the holiday luncheon?
It was really good. Thank you.
Yeah, a special
For
thing.
all those people that put so much work in.
Yeah, Teresa and the transportation and Bill Wagner, lots of people put it together. Sarah Starr, but it was great. It was fantastic.
Food was delicious and the decorations were cute and it was fun. It was good. We had a good time. And the road department all showed up except for
just the
Clint.
Yeah, I was the only one. So we had good participation. I did give the weed department a hard time though, because they were underrepresented.
That's what Brian asked me. Why would we purpose
Yeah, and that's all I have.
All right, Sherry.
Well, it's been a quiet month for me. I have a NORCOM meeting tomorrow in the Dalles, and that is the extent of my responsibilities.
It's good for the holiday season because it's busy right now.
Well, we've been real busy. We've been spending a lot of time driving to Portland, so.
So let me think of what I want to update. I was in Portland on Monday for the Oregon Leadership Summit, which is basically the business community invites in a lot of our statewide elected officials, state legislators, and then county folks. So I saw a lot of our county commissioner colleagues, heard from the governor, heard from Senate President, Speaker of the House. So it was good to hear from them on what they're seeing, what they think 2020 is going to hold. The governor's priority, she did talk about cap and trade coming back onto the agenda. So she kind of put a marker in that. But what was interesting, I thought, was she was asked about it, and she was asked about leadership qualities. She was talking about listening to people, and what she said was that she had heard from the Timber Unity folks, a couple of them, who I think broke through maybe for her. And so it sounds like the approach may be more urban-centered in the next bill that comes out. So it'll be interesting to see if she sticks with that and gets the supermajorities in both chambers to be on board, that they would roll out in Portland and then over time spread so that Eastern Oregon would have more time to adjust to changes. So we'll see. I thought that was an interesting
Sounds like there's some compromise.
Yeah. Other than that, we are just rocking and rolling on finishing up things for the end of the year and putting in place some policy stuff. We're going to be starting to get staff on the agenda for their briefings coming into the new year. Lisa and I talked about sort of standardizing that to kind of, to make sure that the information that's being provided is what we're looking for, but I think also to help staff kind of relax a little bit so they know what we're looking for and can kind of have some templates or some things that are built in that are flexible enough for the different kinds of departments that we want to hear from. So I'm expecting that we'll have our first guinea pigs kind of coming in the first quarter of next year. And once we get those processes in place. The other thing that's really exciting that I wanted to mention is we're going to be sending Lisa to do kind of train the trainer opportunity for a Crucial Conversations program. And Lisa can probably speak to it a little bit more, but just high level, what I'm seeing now that I've been there in a year is that I think it would benefit all of us at the county to have some skill sets around how to initiate and conduct conversations that potentially could be difficult but need to be happening. And so to try to get at some of the cultural things in our courthouse and to give people tools where if there's an issue, they're able to address that in a way that's productive for the environment, as in the work environment, rather than folks either avoiding that or responding in ways that are maybe not as productive for the workforce.
That's a great summary.
Yeah.
So it's basically give us a framework that we can all have those difficult conversations that we'd all rather shy away from, but to be productive and to keep the good work going, we need to have those conversations. So it gives everybody that framework so they can engage with one another in a safe approach. So, nobody's getting personalized or feeling, pointed at or what have you. We're all focusing on
What is the problem of the work we're trying to solve here? So the idea behind sending me to get like a trainer type certification is that I can then bring that back and we have the flexibility to train people because it's a commitment to time to actually do those trainings, and not everybody can fit in with one single schedule, so it affords us flexibility to sort of roll it out to everybody in a way that they can engage along with the other work commitments and priorities that they have. And then also, staffing changes, people retire, take on new jobs, we bring new people in. It makes sure that we can bring those people into that training as well, and that we're all coming from the same place and understanding, the unspoken, if you like, rules of communication that keep us productive and engaged with one another. And you can also use it outside of the workplace.
That sounds great.
Yeah.
I'd like to go.
Me too. Yeah, absolutely. We will. Bring it wide and let anybody who's, can in the first instance have that opportunity to engage with the training, because the more of us that know it, then when I start having a conversation with you, you get the indications of, oh, she's using this framework, this is how I need to engage. So we're all kind of singing from the same platform.
So I'm really excited about that. The other thing, and not to put you on the spot, Lisa, that I'm really excited about is Lisa has developed a framework for her direct reports around their goal setting and her monthly check-ins with them, with the idea that ultimately this will kind of lead into something that you guys should have on your radars for next year, early next year, is the idea is that the staff goals will feed into the strategic plan for the county, so that our staff can see visually how the things that they work on day to day and the things that Lisa's checking in with them day to day impact our vision for the county and overall the livability of the communities that we're trying to improve. Right. So I'm super excited about that. I'm so excited that I'm taking her framework and making myself go through it, because I think it's cool. And the other elected officials, I've mentioned this to them, and they have an interest as well in maybe implementing with their staff. And so she's going to be coming during our next elected officials lunch to share what she's implemented, and then the electeds obviously can take what will work best for their staff to implement it. But this is leading into more regular evaluations and all of those things that we should have been doing all along that we really haven't been doing. And I think the framework that she's got is making it less scary for staff, because they're checking in every month with her anyway, and so there's no surprises then, when their evaluations come along, they will have already sort of had that feedback along the way. And so I'm hoping that that's a way to put in place some of those HR best practices that for the whole reason we wanted Lisa on board anyway.
Yes.
So her purpose. Exactly. So those aren't really my reports, that's Lisa's fantastic work.
Thank you for conveying my
But I'm happy to take credit for it. So anything else in the court reports?
I do have a request. There do come times when we take just pages out of the minutes, which is great, to clarify something. If we added the date as a footer, then, because these 2 pages don't have anything that specifies what day this actual minutes were from. But if each page, then you wouldn't have to worry about, we don't have to include the entire minutes in order to collect what actual date these minutes were
discussed.
What meeting
The date's on the front page.
I know, but the front pages wasn't included. This is an attachment to clarify something.
I'm sorry, I thought you were talking about the regular minutes.
And so if we just had the footer that said what date the minutes were, then it's easy to pull out, just the specifics and attach them to something, and then we know what they are.
Are you talking though about moving forward with those?
Yes.
On minutes from now?
Right, like today.
Yes.
I just want to make sure you get it right on that.
Yeah, go back. I understand. Back and start over.
No, I think that'll be, because I was trying to find, and even in some of this, there wasn't any date on this MOA. So I couldn't tell when it was written either.
Yeah, one of those dates didn't actually have it in the original.
Yeah, no date.
I couldn't find when they signed it, they didn't date it. It was right.
There was no date line in the signature? What's a date?
Does it really matter?
Okay.
Okay.
Yeah, that one has to. Got it.
All right, announcements and next meeting. So our next regular meeting will be January 8th, 2020. I think let's definitely plan on having that work session for the grants. Teresa and I will sort of try to map out what the January 8th agenda looks like. If it looks like it's only going to be an hour, what I'm thinking we may do is do a work session that's 2 hours from like 9 to 11, and then do the regular meeting from like 11 to
Will we
noon.
need do you anticipate needing 2 hours for the work session, this next work session?
It depends on how heavy of a red pen you want to use on the application itself.
I don't think it would hurt for us to allow for that.
Okay.
Because then we done at noon.
The only reason I was wondering is because sometimes we would get done with the work session early and then not be able to start our meeting, and which is okay normally because I'm at the courthouse and I can do some stuff, but I have a dentist appointment.
So
We'll get you out of there by noon, you'll be in Hermiston long before 3 o'clock. How's that for a promise?
I'm writing that down.
the other thing we may be able to do, I'll check with council, is just to say that the regular meeting will follow immediately after the conclusion of the work session.
Yeah, that would be. Now, what can we do? You're gonna check on that?
I'm gonna double check.
I've always heard that you couldn't, because some people may just want to come to the meeting and they need to have a time specific that they.
Well, I think we found that with the Frontier Telenet or the county, Tri-County Mini and Frontier Telenet, they said we couldn't.
But it doesn't hurt, yeah.
The other thing that we could do is potentially, just overschedule it, basically. So say that county court's gonna start at 10, and if the work session goes long, then we just tell people that county court's going to be delayed because work session is going longer than we anticipated.
Oh, there we go.
So.
Because if we're only in
So
another
they
15
show up
or 20 minutes.
They show up at 10, they're not gonna miss it. Where you have a problem is if you tell them it's gonna start at 11 and you get done early and you try to move it up.
Right.
Yeah.
Right.
So.
Okay.
We'll figure it out and we'll send out times, once we see how robust the agenda is. All right, anything else for the good of the order? This was quite
Long.
You asked for more than 2 hours in this meeting, and you got what you asked for.
I need to clarify.
Okay, it is 1:33, and I